Good afternoon, ladies and gentlemen, and welcome to the regular meeting of the San Francisco Ethics Commission for September 26th. And before I turn to the agenda, I want to take the pleasure of introducing our newest commissioner, a man who I think is known to many of us in San Francisco who have lived here for a long time, a man who has devoted his life to public service, and we're honored that he's willing to now serve on the Ethics Commission. Quentin Kopp, welcome.
Thank you, Mr. Chairman.
All right.
It is a pleasure to be with you and Vice Chairman Kane and Commissioner Cho.
All right. Turning first to...
Can I just echo it with a
Certainly.
few more words? I mean, we're really graced with a legend in terms of having Judge Kopp as a member here. He's been involved. I've known Judge Kopp for 45 more years. And he, as a supervisor of the City and County of San Francisco, as a member of the State Senate, as a judge, things like the State Bar. He and Judge Kopp and I were involved in the plebiscite matter relating to the State Bar. We've sort of both carried it together. He is indeed a tremendous mainstay in terms of protecting the integrity of the political system of San Francisco and in San Francisco. And we're really blessed by having him as an asset on our membership. So, Quentin, I couldn't be more delighted.
I'm grateful.
Item 1, call to order and roll call. Commissioner Han has been excused. Vice Chair Commissioner Keene.
Here.
Commissioner Chu.
Here.
Commissioner Kopp.
Here.
All right, all present and accounted for. And I will, for purposes of the public being aware, the item number 11 on the calendar has been continued to our next regular meeting in October 24th, 2016.
Mr. Chairman,
Excuse me, Commissioner Kopp, please put the microphone in front of your mouth when you're speaking.
All right.
We appreciate it. Thank you.
I don't think I've ever heard anybody say they couldn't hear you.
I am going to be in New York City October 24th, and I would like to be present for consideration of the matter comprising item number 11. And I therefore ask the chair to give consideration after tonight's meeting to perhaps continuing that a week. I'll be back October 30th.
That's fine. I will ask Ms. Pelham to poll the commissioners for their availability in the latter half of October.
Yeah.
And we will send out a notice of the rescheduling the regular meeting, which is scheduled for the 24th, to a date which is agreeable to all 5 commissioners. All right. Thank you.
Thank you, Mr. Chairman.
All right. Now calling for public comment on matters appearing or not appearing on the agenda.
Members of the Ethics Commission, if we can get this on the overhead. This is a listing of the 27 orders of determination that I have had issued by the Sunshine Ordinance Task Force finding various violations against city agencies and elected officials. 7 of these were referred for hearing to this Ethics Commission, 5 of them being dismissed without a hearing for various specious and false reasons. The 2 that were given a hearing both related to the San Francisco Public Library. Ethics Case 01130307 resulted in a completely dubious finding given that the Ethics Commission had itself been found in violation for willfully disregarding the Sunshine Ordinance in exactly the same matter, which is Order of Determination number 11088. In other words, you were hearing a case on which you were found in violation, a case that was against the library for finding the same violation. The most interesting thing is the library continued to refuse to follow the orders of the task force until it had found 3 violations against it, and then everybody, including this body, finally shifted and obeyed what the task force had ordered it to in the first place. Willful disobedience, both on their part, and it's kind of ironic that you're hearing a case against somebody that you yourself were in violation of. Finding the library in violation would have necessitated finding your own body in violation. The hearing itself was a clear ethical screw-up. Ethics case number 031200402 was heard while I, the complainant, was out of the state. Magically, the referral made it over in less than a week, and the history of the referrals from the task force to this body has been typically a minimum of 4 months. Mine made it over in 7 days. And you had the hearing the day before I returned to the state. Wasn't that convenient? We have such a case on today's agenda, and I predict a finding of no violation. I can already read you guys like a book. You have no intention at all of ever fulfilling your obligations under the Sunshine Ordinance, even though that law specifically shows you as being the body to enforce it. You have done absolutely nothing in all these years to enforce it except pass one finding against one city official, which the mayor ignored, and when we shamed you into sending a letter to the mayor repeating the fact that you had unanimously recommended the president of the Library Commission be removed, he ignored that. This is the most impotent body in the city of San Francisco.
Mr. Chairman, may I ask the gentleman for his name?
My name is Ray Hartz. I'm Director of San Francisco Open Government.
Thank you.
Thank you.
Good evening. My name is Michael Petrellis, and I'm here to address a matter I brought to your attention previously, and it has to do with a complaint I filed on February 25th of this year, 7 months ago. It was a complaint against the mayor because of...
We allow
Excuse me?
campaign signs to be displayed?
I agree.
Take that, put your
campaign sign down.
Campaign outside this hearing room. This hearing room is not a format.
Please stop the clock. I want my 30 seconds returned to me that you've taken up by interrupting me. And if you'd like to discuss signs in the meeting, I would like to see in writing the prohibition that prevents me from holding this sign. I want to see it in writing. Why you are telling me to put a sign down, because I feel you are infringing upon my First Amendment rights. Can you produce in writing the prohibition that you say is the reason why I have to put my sign down? Yay or nay, can you produce it in writing?
Chair of the commission, I can make that ruling and ask you to put it down. Where's that in writing? And if you...
Where's that in writing?
If you aren't willing to put it down, then you can just step back. This room is not for political...
Why are you trying to infringe upon my First Amendment rights without producing in writing what you say are these rules?
Through the chair to the city attorney, is it legally allowable for a candidate for office to use his campaign material in testifying before the commission with a television audience of which he certainly has knowledge?
Off the top of my head, I'm not sure. I mean, it does seem like campaigning is not within the scope of the Ethics Commission's jurisdiction, and so I think
I suppose it's within our scope also to offer an opinion under the First Amendment on the merits or demerits of his candidacy. Mr. Chairman, I would like a written opinion. It ought to be short on this kind of campaign advertising in a
and I would like to point out, regardless of what my sign says, I want to see it in writing.
To you, sir.
You have interrupted my
talking to the
public
chairman.
comment, sir, and I will not be cowed by this. I am holding a sign regardless of what it says. You claim you have a prohibition on holding these signs, that you cannot produce it in writing. I'd like to hear what the city attorney has to say is in writing regarding a public comment speaker holding a sign, regardless of what it says.
If you'd like a written opinion, I can provide one to you forthwith, but until that time, I don't know the answer off the top of my head.
Well, within a week or so, before the next meeting.
Go ahead with your comments.
Thank you. Please return my
Make it
30 seconds to me.
clear that you are not politicking and
I
running
am
for
not
office.
talking about my candidacy of all. If you would let me finish, I would complete my 3 minutes. Are we ready? I am here tonight to talk about a complaint I filed with the San Francisco Ethics Commission on February 25th against the mayor and Willie Brown. It pertained to my complaint pertained to a October 1st meeting in 2015. I'm going to show the sign-in sheet from the mayor's office on the overhead. Can we please go to the overhead, please? As you see here, there was a meeting on October 1st. It was at the mayor's office. Among the attendees, the last person listed as an attendee is Willie Brown. And the column next to his name says his organization. He did not fill in the name of the organization or the entity that he was representing at this meeting with the mayor. Please come back to me on the camera. Other folks who were at this meeting include representatives from the East-West Bank. Now, the law says everyone attending meetings with the mayor has to sign it, print their name, and list the organization or entity they're representing. Willie Brown did not do that. That is the basis of the complaint I filed 7 months ago. All I have received from the Ethics Commission since this complaint was filed was an acknowledgement that you have received the complaint and you're checking it out. I'm here to ask you to direct the researchers at the Ethics Commission at 25 Van Ness Avenue to move on this complaint. I'm wondering how many other complaints have been filed along these same lines that are waiting for an investigation, but are not happening. It is not serving the public. It is not fulfilling your mission as the Ethics Commission to have a complainant wait 7 months. Now, I don't expect by the time we come to next month's meeting, or if it's happening, when we come back in a month or maybe in November, I don't expect that we're going to have a resolution to this. I've received no indication from the Ethics Commission that they're investigating. This kind of approach to processing a complaint is harming San Francisco transparency.
Any other public comment?
Mr. Chair, if I could only comment that I've been aware of Mr. Petrellis the other times he's come, and the actual complaint he's been making has troubled me. He has compromised the effectiveness of his bringing forth this complaint with his cheap stunt of holding up a sign to elect him to the BART membership while attempting to give us this this complaint once again. So I think his sincerity in terms of this presentation and his effectiveness in terms of his presentation, you just wiped every bit of it out, sir.
I would like to respond and disagree
Mr.
with
Chairman,
you.
may I-
I have requested in writing your rules
I'd be
about signs, and you
recognized,
can't
Mr.
produce it. You have jeopardized your ethical standing. You are not going to demonize a member of the public and not expect a response.
Yes.
I want to associate myself with Vice Chairman Keene's remarks in totality. And secondly, at the time the executive director reports, I want to ask a question about the list of pending investigations and complaints. I can't recall if this is one of them or not. There were a number of them. And I'm fully aware of the fact that this is a new administration of the Ethics Commission in all respects. I have questions and am even troubled by the delays in some of the investigations that are set forth as part of the report to the Commission. Thank you, Mr. Chairman.
Right. Item 3, discussion and possible action on draft minutes for the Commission's July 25th regular meeting. Commissioners, anyone have any corrections or changes to those minutes?
Move approval.
Second.
All right, public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. These minutes are an example of the disservice this body and others in this city do to individuals making public comment. Although speaking in most cases for 3 minutes, each person's public comment is boiled down to 1 or 2 lines. There is no reasonable attempt to provide a meaningful summary of what was said. What is certain to appear is any comment that praises this body and or its staff. You can go through these minutes, and there are at least a dozen occasions where it says, oh, the staff is wonderful. Oh, the Task Force Ethics Commission is wonderful. You don't edit those things out. You just take out anything critical. What is certain to appear is any comment that praises this body or its staff. Members of the public may have noticed that at a conclusion of each public comment, I pass a 150-word summary to the staff. I work on the premise that taking time to make thoughtful public comment, exercising my constitutional rights, is worth a little time ensuring that it is accurately reported in the official record. Constitutional political free speech rises to the highest level of protection of any form of speech. I think the 4 of you who are attorneys, all of you, realize that, and you also realize that their representation in a printed document by the government is also extended the same protection. The reason being, I want to make sure it's accurately recorded. The reason being that bodies such as this will censor, abridge, misrepresent, or otherwise remove public criticism. And no, let's not be stupid. I'm not asking for the minutes to be a transcript, but at minimum, a reasonable summary. I put in my 150-word summaries, and I fought this body and 4 other bodies for 2.5 years. And basically everyone just refused to put these in the minutes, even though the Sunshine Ordinance clearly says that if this summary is submitted, it will be placed in the minutes. The task force, I had to go back 6 times until they finally issued a letter saying that the city attorney's information in the Good Government Guide is not a legal opinion. In fact, from what I know, the city attorney has never offered any legal advice or legal opinion on the Sunshine Ordinance at all. All basically that happens is he tells people something and you tell everybody, oh, well, that's attorney-client privilege, so you can't know what he told you. And then they show up at a hearing at the task force or somewhere else and say, well, the city attorney advised us this. And then you say to somebody, well, will you have the nerve to actually ask a deputy city attorney who's right here whether that is advice that the city attorney's office would actually give someone? And nobody will do that. Basically, you will do exactly what Mr. Petrella said. You will interfere with people's constitutionally protected political free speech at your will.
Thank you.
Mr. Chairman, not apropos of that, and I'm not competent to vote on the question presented since I was not present and I was not a commissioner. But I'm curious, as a point of information, about 2 or 3 places where all I see is a reference to a first name. Maybe the executive director can explain, is that an omission of the last name, or are people allowed to testify by giving only their first name?
Allowed to testify without giving a name.
Yeah. Thank you for the question, Commissioner Kopp. It has been the practice that individuals can come before the commission and give their first name. They do not fill out a card. So they have provided a first name, and we don't always have that information.
Let the record show that I am liable not to give weight to somebody who only provides a first name. And then there's a reference to a Catherine or Charlotte Hill. I think you want a capital H on that to be free from literary criticism.
Thank you for that careful review.
And may I be excused from voting on the...
I'll call the question. All in favor?
Aye.
Opposed? The minutes are approved unanimously. Turning to item number 4, discussion and possible action on hearing on the merits for complaint number 19-131115 in the matter of Lynette Sweet and Sweet for Supervisor 2010. This matter was before the commission 2 meetings ago?
In March.
Yes, and at that time, there was a proposed disposition which the commission did not approve and requested some further additional information. As I recall, we were troubled by the fact that she was a candidate who received public financing, and there was some $20,000 approximately that could not be accounted for. And I think the earlier report had said that most of it, she said, had gone to pay staff members, but there was nothing to support it. And we asked for the staff to look further to determine whether or not those representations were correct.
Right, and we don't have any additional documentation to evidence that. And she has not provided anything, and since the meeting in March, she has been mostly uncooperative and non-responsive to staff.
Well, did anybody on the staff seek to contact the individual who she says she made payment to?
There were various staff members, and it was difficult to obtain actual contact information for most of the people that were listed.
Go ahead.
Okay. Yeah, I don't know. Did you read this? Okay. Thank you, Commissioners. Catherine Argumetto on behalf of the staff of the Ethics Commission. This is a hearing on the merits regarding ethics complaint number 19-131115. It does not appear that the respondent, Lynette Sweet, is present tonight. Staff notified her of the hearing 2 times and has provided her copies of all the documentation that staff has submitted to the Commission. This matter involves 10 violations of the Campaign Finance Reform Ordinance, 7 violations of Section 1.106, where respondents failed to file campaign statements, 1 of Section 1.109, where respondents failed to maintain records documenting the committee's activity, and 2 of Section 1.118, where respondents failed to pay campaign debts within 180 days of them accruing. Staff believes that a person of ordinary caution and prudence would conclude that the respondents have committed these 10 violations of the Campaign Finance Reform Ordinance based on a preponderance of the evidence presented. Respondents Lynette Sweet and her candidate committee, Sweet for Supervisor 2010, have provided no response to staff's hearing brief and have not contested any of the charges that staff has presented since its accusation in February 2015. Lynette Sweet ran for District 10 Supervisor in 2010, and she and her candidate committee requested public funding. Overall, her committee received $57,439. As a recipient of public funding, the staff was required to perform an audit. During the course of the audit, Respondent Sweet failed to provide supporting documentation for $61,000 in expenses and $8,750 in contributions. After staff issued its audit report in July of 2014, which respondents did not provide a response, Respondents provided additional documentation to enforcement staff for $41,588.27 in expenditures and $4,150 in contributions. Approximately $24,803 remains outstanding without any supporting documentation. In addition, respondents have failed to file any campaign statements since filing the statement covering activity through the end of December 2010. Whatever committee activity has occurred, if any, has been outside of the public eye. Respondents also have 2 unpaid expenses totaling $4,650. These debts, as they've remained unpaid for over 180 days, are now considered unlawful campaign contributions from corporations, and therefore staff requests that the Commission order forfeiture in the amount of $4,650. In addition, staff requests that the Commission assess an administrative penalty of $50,000 based on the maximum administrative statutory penalty of $5,000 per violation. The Charter permits a maximum penalty of 3 times the amount improperly reported, which in this case is $74,409.18. However, because Respondent Suite cooperated to some extent with staff, staff recommends that the Commission assess the maximum statutory penalty of $50,000.
If I might.
Yes.
Mr. Petralis, you are holding that sign up specifically for TV. That is not allowed. Put it down or leave. Take your choice. You want to get the bailiff here?
Oh, there's a button under there.
Call the bailiff.
It's under, I think it's...
You'll do anything to shut people up, won't you?
Actually, is there a phone number on the screen for the sheriff's office? I don't remember. Yeah, I think maybe we can... There's a phone right there. Sorry.
Yes, please. You're perfectly welcome to stay here, but you aren't welcome to campaign here. And if you think you are, you'll contest it. Thank you. All right, go ahead.
Would you like me to continue? Okay. So respondents' violations were severe and negligent. They violated the public trust by failing to file required campaign statements. The public was and is still unable to monitor what activities have occurred after December 2010.
I also put that down. I'm sorry.
That's okay.
Go ahead.
I can't see what's going on, so I don't know.
Well, is a bailiff en route?
Yeah, why don't you get him? Because this gentleman is just playing the role of a clown very effectively and distracting everybody.
I'm standing up for free speech, and you have to produce in writing what you say are your rules.
Would you like me to continue?
Yes,
okay.
please.
So Respondent Suite previously ran for elective office in California and had been subject to all the reporting and campaign finance requirements set forth in the Political Reform Act, which have been incorporated by reference into local law, the Campaign Finance Reform Act. So in applying for and accepting public funds, Respondent Suite consented to increased scrutiny from the Commission and the public about how she financed her campaign. Respondents knew the requirements for record keeping and knew that they would be audited. And yet, respondents failed to maintain the required documentation to support the committee's activity. Respondent Suite has been largely uncooperative and non-responsive to staff regarding this matter, and she has continued to fail to file campaign statements. Staff requests that the Commission admit the documents that staff has presented, including Ms. Sheikh's affidavit and attached exhibits, as evidence, and rely on them and make a determination that respondents committed all 10 violations of the Campaign Finance Reform Ordinance. Based on the law and evidence as presented, staff respectfully requests that the Commission issue a final order declaring the respondents committed all 10 violations, assessing administrative penalty of $50,000, compelling respondents to produce the missing documentation and file all campaign statements as required, and ordering the respondents to forfeit the $4,650 in unlawful campaign contributions. And I'm happy to answer questions.
Any commissioners have any questions?
I have a question of a general nature. I've read 2 files or 1 file, folder. And I'm struck by the fact that your recommendation is based in part upon cooperation. And I draw a conclusion that the cooperation has been minimal, superficial, and that rather the respondent or respondents have defied the law, as well as taking $7,439 and some odd cents from the taxpayers of San Francisco. So I suppose your finding of minimal cooperation is based upon experience.
Yeah, I mean,
But I'd like to get your thoughts on it.
yes, I think that had she not provided any additional documentation, so had staff not received anything during basically the investigatory phase, then I think it would be different. But she had participated, and there had been communication with staff. She just has not in many months. But I mean,
like
it's the commission's
continuum.
right, and it's the commission's discretion to decide any penalty. So the $50,000 is a recommendation from staff, but the commission has the ability to go up to 3 times what was improperly reported, which was over
I know.
$74,000.
All right. Thank you. I'm ready, Mr. Chairman, to make a motion to impose a penalty of $74,409.18. This has consumed so much time. This was for an election when? In 2010, 6 years ago. Not a good record, not a good record. And this candidate had already been a candidate for a public office, which involves the kind of time and effort in keeping track of donations, expenditures, reporting under the Fair Political Practices Act. And in effect, now she has thumbed her nose at the system, and as I said before, come away with $54,000+ of public funds. Anyway, I'm prepared to make that motion.
Do I have a second?
Yes, I'll second the motion with some dismay, actually, because the last time we had Ms. Sweet here and her attorney here, and they made some presentations which, in my opinion, indicated some mitigation, and that was, at that time, I think myself and Commissioner Andrews were somewhat sympathetic to her general plight and a certain degree of haplessness, and we were persuaded also by what the city attorney at that time said. There was a fair amount of cooperation. Really dismayed to hear that since that last time, Lynette Sweet has then decided to not cooperate at all and has just stonewalled and as Commissioner Kopp said, thumbed her nose at us in regard to this rather serious violation. So at this point, I'm not inclined to have the thoughts of mitigation that I had up till now. So I second the motion.
Chair Rennie?
I've got to say that I was a little bothered when I read the amount of money that the staff was recommending that we assert against Ms. Sweet, because of the fact that when it first came before us, there was a proposed settlement of the matter with a payment schedule And the main concern was the fact that there were public monies that were unaccounted for. And to have it come back, but I agree with both Commissioner Kopp and Commissioner Keene that the record since that time, instead of being cooperative with us and trying to resolve the problem that we raised at that last meeting on a show cause, that she has just thumbed her nose at us, and so that I'm disposed to go along with the amount of the fine, with the understanding that clearly it's my sense that she probably doesn't have the financial resources to reimburse and pay a fine of $77,000, but that we'll get some cooperation once the order is issued against her. But go ahead.
Chair Rennie, I would agree with my fellow commissioners. I'm very troubled by the fact that she has exhibited such disregard for the process and has not cooperated in any way. And I think that I was not here for the initial show cause hearing, but any mitigation efforts are non-existent with regard to the final disposition of this case, and that she's had numerous opportunities to work with you as well as to attend this hearing this evening. So I would be inclined to agree that the full penalty is inappropriate.
All right, any public comment before I call the question?
I'm sorry, but may I ask one more? I just wanted to, I'm not sure whether the commission would consider the forfeiture amount that staff had presented regarding the
That
unlawful.
will be my next motion.
Okay.
Or do you want it procedurally? Should it be in one motion?
It's up to you whether you can do whether you do
All right,
one or the
I'll
other.
include that, the $46.50 as a forfeiture.
Okay. Is that accepted as a second?
Second.
Public comment?
Ray Hartz, Director, San Francisco Open Government. This is one of the items that I did not make 150-word summaries because all I could see from the documents that were attached were you having an argument with yourself. Larry Bush sent a letter in here. He says, note that in a case that is far less significant, the staff recommends to Lynette Sweet a fine of $50,000, which is double what you're looking at Mr. Farrell's proposed fine, even though he was found by you to have violated the law in the degree of $193,000. So you're going to get 12 cents on a dollar from him, but you want her to pay full tilt. One set of rules for the city officials, one set of rules for everybody else. Bottom line is, you have these hearings about a case that happened in 2000. Where the hell was the staff for 4 years, which is the first document I can see in these records, to show that you were doing anything regarding this? If I were running a campaign in 2010 and somebody came to me 4 years later and said, produce documents, I'd be going, hell, the IRS only expects you to hold your records for 3 years. You're worse than the IRS. And I think it's kind of hypocritical, and I agree with Mr. Bush, although he may not like the fact, that for you to have one set of rules for Supervisor Mark Farrell where you're going to settle with him for 12 cents on the dollar, and yet you're going to impose the maximum fine you possibly can on Lynette Sweet, seems a really strange set of circumstances. I'm curious as to why my clock isn't running at all. Am I just have unlimited time? Okay. Basically, I have to agree with Mr. Petrellis is that this is politics. It is nothing but short, sweet politics. And therefore, everything that is said here by you and by the public is constitutionally protected political free speech. And people arbitrarily coming up with rules where they say, oh, we have a rule in the chamber, you can't do this. And if you violate the rule, the forfeiture penalty is your constitutional rights. David Chu did that to me once in the Board of Supervisors. I chose to start my comment with the word Gestapo before I got to the podium because I had 3 sheriff's deputies that I had to weed my way through because they were trying to hustle away the person who was speaking before me. And David Chu says, oh, I don't think we'll let this speaker speak today. Now tell me, all you lawyers, is it an unusual penalty when breaking the rule of a chamber to have your constitutionally protected political free speech forfeited? Doesn't make a lot of sense to me. And the interesting thing is, people say to me, why aren't you more friendly with them? Why don't you try to be agreeable? I said, because you don't get anything when you're agreeable. They sit there in dumb, mute silence. At least when you're in their face, you sometimes get a reaction. And if that's all you'll give, then don't be surprised what you get. And as President Truman once said, if you can't stand the heat, get out of the kitchen.
Mr. Chairman, I realize, having been away from this kind of civic endeavor.
Welcome back.
Yeah, that now electronics have taken over. So anybody can get up under a law which I created and make statements that are not just incorrect, but are also misleading to people in the public domain. And therefore, let me note that each case has different factual issues and different legal issues. And there is no comparison between the legal issues in item number 11, the so-called Referral case, and this item, the Sweet case. None at all. And with that, I would call the question.
I still have public comment.
Michael Petrellis again. I want to echo what Ray Hartz just said and build on it a bit. You guys are politicians, and Professor Keene is frequently...
No, sir. I am a lawyer. And I resent your characterization of my colleagues and me. I have held public office, to be sure, honorably. And I have served as a Superior Court judge, but I am a lawyer now, and I intend to act like a lawyer, and I resent your personal remarks about my fellow commissioners or me. And you'll get your 30 seconds.
Is there a rule about not being interrupted?
Proceed.
I want my 30 seconds back, please, before I was rudely interrupted by politician Kopp, and I would like to have my free speech rights respected for 3 minutes. If it's possible for the members of this esteemed commission to control their egos and mouths just for a little bit.
Just proceed
now,
with your comments.
I want to echo and support what Ray Hartz said regarding the politics that are behind some of your decisions and that certainly come into play about what gets put on your agenda. I want to know if there are rules that are going to say how long you will have a time limit on responding to the public. What are the rules of decorum regarding you trashing members of the public using their 3 minutes and allowing us to respond? If this is how politician Kopp is going to be conducting himself in the future, with interrupting public comment, with responding to every public comment, and doing so without a time limit, it's more of a disgrace upon this commission, which is ethics commission, good government. I am suggesting you practice it at every meeting and that you really work at controlling your privilege and do not interrupt public comment and do not respond to every public comment. Ray Hartz has a point. You should listen to him without dismissing it and without boosting your own egos. democracy and good government in this building are suffering. They are suffering. Professor Keene, you were talking about the legendary cop returning to City Hall. Well, I don't know what's so legendary, and a lot of other people don't, and we don't want, or I'll speak for myself, I don't want to lecture about who you think is a legend. I want a stronger Sunshine Ordinance task force. I want better enforcement of sunshine laws. I want orders of determination carried out. I want this panel handling complaints sooner. I want the Ethics Commission investigators investigating complaints and closing them sooner. There's a lot of good government that needs to be done, and I don't hear you talking about it. But you are going on and on about some unwritten rules regarding decorum for these meetings. Let us see these written rules you're talking about.
Thank you. Any other public comment?
Good evening, Commissioners. I'm Charles Marsteller for the record, and I am with Friends of Ethics. I want to welcome Judge Kopp to the Commission. It's very good to see him here, and thank the Board for their appointment. I also am doing so on behalf of Friends of Ethics, and the Commission should have received by email a copy of the final letter signed by Friends of Ethics and not by Mr. Bush. The one by Mr. Bush is in a document that was in process. This is the one you've received signed by Friends of Ethics are the legal points that we wanted to make on these several items on our agenda tonight. I've said many times before this body and to the public that the law for public financing was clear. We have a proactive and concurrent enforcement mechanism so that the use of public funds is in fact indemnified by the process that we have set up, which is you and me, and Friends of Ethics, and other individuals in the public sector who are interested in the integrity of public financing. That promise must be maintained. So 5 years is not acceptable. However, I think in this case it's useful because we will see by an examination of the process exactly where the points were that created problems at many levels. One was the concurrent expenditure of funds and later enforcements. I think that if you open up the books and look at what happened in this case, we can tighten up our concurrent and proactive auditing program to make it much more effective, and I have a number of ideas, and I would be willing to discuss with you that in a public session or privately, however you wish. But I do want to say that I think we can learn a great deal from this case, and I think it's essential that we do. And however you wish to decide it is your decision, but I'm the person that worked hard to set up the process, and I want to see the process work and be guaranteed by you.
Thank you. Any other public comment?
Good evening, David Pilpel. I guess I don't have to say speaking as an individual since I'm no longer on the task force. Welcome to State Senator and Judge Kopp. I found my official membership card from Kopp's Good Government Committee from 1992 when I was going through some records recently, back in the day. Wanted to speak in support of staff's recommendation and the motion before you. I think the violations are pretty substantial. There's been a fair amount of history with this individual. If I recall correctly, the respondent may have served on the city's redevelopment agency board for a period of time and served as a member of the BART board, certainly was an appointed elected official, should have been familiar with timely filing of forms and the record-keeping requirements associated with running for office, particularly as a publicly financed candidate. So I support the recommendation and hope that you'll follow through. Thank you very much.
Any other public comment? Would you state for the record again exactly what
Yes.
Mr. Kopp's motion
I
is?
move the commission assess the respondents as a penalty $74,409.18 and order, secondly, a forfeiture of $4,650 received from corporations.
That was second.
Second.
All right. I'll call the question. All in favor?
Aye.
Opposed? All right. The motion is carried unanimously. Turn to discussion on item 5, which is discussion and possible action on the Sunshine Ordinance Task Force referral for enforcement against Steve Kawa, complainant. And as I understand it, notice is given to both Mr. Kawa, the mayor's office, and Mr. Petralis.
Yes. Your Honor. Is it possible for me to ask one thing from
Yes.
the prior agenda item? Just, is that,
All
I
right,
don't know.
no,
Okay.
go ahead.
So I was wondering whether the commission would want to consider compelling the respondents to file the campaign statements they have not yet filed?
To file what?
The campaign statements they have not yet filed?
Oh, you mean on the
Or at
last
least a
item?
terminate-
Yeah,
or at least a-
I don't know. Isn't that moot? I defer to my seniors in service, but to me it seems,
Well, I guess the one thing is, it's a way to stop the clock keep running, because she has not filed a closing statement, and what you're asking for is an order of the commission to order her to file the closing statement,
Correct.
right?
well, this is a procedural nicety.
I think it's-
Go ahead.
Well, I think since it is a continuing obligation to report, that such an order would be appropriate. Until she has reported, she has not fulfilled her obligations under the law, and it's a continuing violation by not reporting. So whether we have to order her to do it or not, I don't know, but we might emphasize the fact that
You want to make a motion?
I move that in addition to the other sanctions, that it be noted that Ms. Sweet continues to not provide the reports in accordance with law, and it is also noted that therefore she is under a continuing violation of the reporting statutes. And I'd make that part of, I guess, the finding, the resolution.
No, and I take it that what we are doing by that is empowering the commission then to have the city attorney bring some action to compel her to do it, other than being in contempt of court, right?
Right. I mean, she would have I suppose she would have now a dual obligation, right? One under the statute and then one under this commission's order.
Mr. Chairman, may I ask a question to Mr. White? Does the tax collector have his own lawyer for the Bureau of Delinquent Revenue?
Yes.
Okay. But I have in mind that our resolution then is transmitted to the tax collector, who delivers it to the Bureau of Delinquent Revenue, who probably sends out a courtesy letter saying pay up by a certain date, and if no payment, then files an action in Superior Court. And then Ms. Sweet can decide whether to default on the obligation to respond to a complaint.
Generally, that's correct.
Yep.
If I may, a good compromise solution might be simply to order her to file her termination statement, a 410, to end the continuous requirement for the 460s.
Right.
Just to say, file the termination statement, and we'll be done with it.
I'd so move that the commission order that.
Commissioner Kopp seconds. Any public comment on that portion that we are now back to 4?
Commissioners Ray Hartz, Director, San Francisco Open Government. I don't purport to be an expert on Robert's rules, but I think what you just did is a violation of them. If you make a motion and you pass it, and then you make another motion to change it, you have to go back and rescind the first motion and make a new motion with the proper inclusion, not simply make a second motion and say, well, they're, interrelated? I really don't know what it is you're doing, because you're basically all having a nice little conversation up there with each other and ignoring the fact that there are a lot of the members of the public here who came to participate in this, not to be simply ignored, as is your wont. And if you're going to make any responses to any of my comments, please be kind enough to be specific rather than make some sort of vague, oh, he said something false and he did this. You're beginning to sound a lot like Donald Trump.
So just FYI, the commission does not have to take public comment anymore. The requirement is once per agenda item, and that's already happened. So there's no need to allow further public comment, but you can if you would like to.
Because we made a second motion.
It's once per agenda item, not once per motion.
I don't think that motion's necessary. I think as a matter of, well, someone else wants to.
Go ahead, Mr. Bell.
Just very briefly, David Pilpel, I think the commission is fine to make a second motion related to the agenda item, and to the extent that this motion, if passed, would require or seek to get the respondent to file a terminating statement, it's probably helpful to the overall effort. So I support it. Thanks.
I'll call the question. All in favor?
Aye.
Passed unanimously. Now turning to item 5, discussion and possible action on the Sunshine Ordinance Task Force referral for enforcement against the Steve Kawa complaint 04160718. Staff.
Yeah, thank you, Chair. Jessica Bloom for the Ethics Commission, and I just wanted to give a little bit of context to what the situation that's unfolding. I understand it's not every day that the staff would write a recommendation or a memo on a Sunshine Task Force referral item, and I just wanted to explain a little bit what's going on. So the Sunshine Ordinance Task Force has found that Steve Kava, who's the mayor's chief of staff, to be in violation of the Sunshine Ordinance for deleting his calendar and his electronic calendar, not producing it to a requester. The task force referred that finding to this commission for enforcement. And normally you have the option to hear that type of case, and the staff is not recommending that you walk away from that obligation. But we did notice in the file that there was a city attorney had written a memo to the task force, and we correctly predicted that the city attorney would be writing a letter to this commission, and we wanted to sort of analyze all of that information together and provide you with our best recommendation, our best analysis, and independent thought on the matter. I will note that our memorandum was drafted prior to the city attorney sending their letter to the commission, but I did incorporate their arguments into our memorandum after the fact. Essentially, what the city attorney is arguing, I think, is that the electronic calendar is not at all a public record, and therefore there was no violation of the Sunshine Ordinance at all, nor was there a violation of the record retention policy. Whether or not there's a violation of the record retention ordinance, however, in our view, is not really relevant to the inquiry, because neither the task force nor this body has any enforcement authority over the record retention ordinance. Unfortunately, or fortunately, however you want to look at it, the Sunshine Ordinance itself does not incorporate the record retention ordinance. And so those are two separate bodies, two separate pieces of law. Our authority rests in Chapter 67, which is the Sunshine Ordinance, and then the district attorney and the attorney general have enforcement authority over the record retention ordinance. Whenever there's a willful violation, it's justifiably a crime. And that's actually very common among jurisdictions. I hail from the state of Missouri, where both are together in one statute. So the Sunshine Ordinance is both records retention and public and disclosure requirements, but a willful violation is nevertheless a crime, and the district attorney and the attorney general have a jurisdiction over the enforcement of the crime. So what we have here is a little bit unusual because they're separate, they're bifurcated, but we have to follow our charter, and so that's the reason why I put together that memorandum. Essentially, our argument or our analysis is that because they're separate and the Ethics Commission's jurisdiction is arguably fairly narrow in these types of matters, we really can't do anything about whether or not Mr. Cava should or shouldn't have deleted his electronic calendar, even if we think he shouldn't have. And I do say in my memorandum, and I stand by this, I think that his electronic calendar is a public record. So that's basically my analysis. In the end, you have a choice before you. You can make a policy decision in the same way that the task force did to incorporate the record retention law. That policy decision is best left in the form of a call for a change in the law, a call to the Board of Supervisors to incorporate the record retention ordinance into the Sunshine Ordinance, so there's some teeth there. It's arguably not a good an enforcement action. An individual exercise of enforcement is not the best place to make that policy decision, in our view. But you could make that decision, so we just wanted to make you aware of that. And therefore, in our memo, we highlight the ways in which the Ethics Commission can enforce the Sunshine Ordinance. Unfortunately, there's no real way to deal with a past violation like this. That's you can't really fix. We don't have penalty authority. You can't go back and order him to recreate the calendar. And I think that the reason why those enforcement penalties don't exist is because the ordinance doesn't contemplate this type of situation, because a deleted record is not a retained record and therefore not something that could be produced. So I leave you with that. I'm open to questions. I believe you also have someone from the mayor's office here, and Mr. Petralis is obviously here.
I will let Mr. Petralis have 5 minutes to make your case.
Before I get started, I want to try and zoom in on the city attorney's letter on specific. How do I? There. Okay.
Which
we
letter
can
is this?
Start the clock.
Is this the September 15th letter?
Yes, the September 15th letter, page 3.
Thank you.
Hello, my name is Michael Petralis, and I am a proud muckraker, and I like to look at public documents from international governments, federal government, state, and local government. And I filed a request earlier this year for Steve Cowa's calendar and emails. And in one of the responses from the city attorney dated September 15th, the city attorney cites as the Good Government Guide, page 12. The city attorney writes, and I'll read, "The vast majority of public records in the city's possession do not fall under the definition of records within the meaning of records retention law. Therefore, the city may destroy these records at any time. For example, as a general rule, employees may immediately dispose of phone message slips, notes of meetings, research notes prepared for the personal use of the employee creating them, and the large majority of email communications." Okay, SFGov, please come back to me. I'm finished reading. It is very disturbing that the city attorney continually cites the Good Government Guide and fails to mention it is not law. And to have the city attorney state that many of the records, actually the vast majority of public records, do not fall under records retention law is in and of itself very disturbing. We need a city attorney who's a sunshine watchdog, not a lapdog to the mayor's office and other folks at City Hall. I cannot be worrying about the city attorney's next race and who he's trying to please politically. To have the city attorney go on to state that the large majority of email communications, they may be immediately disposed of, is very disturbing. Now, to come back to my request for Steve Cowa's calendar, let me show on the overhead again. We can just go back to, you can see this is Cowa's calendar from July 13 through July 19, 2015. Totally blank there. Now, a few weeks later, he did produce a calendar listing what time a meeting began, and that was a good start. But I want you to really take into account the blank calendar. Do not interrupt me. I really want you to...
You want me to take you seriously? What are you referring to? You said a couple of weeks later.
May I have my 20 seconds back that he interrupted for? I want my public comment presented, which is about this case. I want to present it uninterrupted.
It would be helpful if you could let us know what page you're referring to.
I am looking at Item 5, Attachment 1. It's a June 30th letter from Leanne Pelham. And in the back, the document does not list a page number at the bottom for the actual document, but it lists number 2 page for the calendar that was provided to me. If you can look at July 6th, 2015 through July 19, 2015.
Thank you.
Have you seen these? You see what I'm referring to? Okay, let's start the clock.
It was the question, next question. You said, but he showed you something later that had an entry in it, and that's what Commissioner Kopp was asking.
All right, I'll answer that as long as you're not eating into my time. Flip a few pages forward, please, and you'll see, for example, on February 15 through February 21, 2016.
Later. All right, go ahead. I'm with you. Let me ask this further question of staff. How were these February 15th up to whatever it was? How were those obtained? Was that voluntarily provided by Mr. Cowa?
Commissioner, I believe that, so Mr. Cava was deleting his emails manually every 2 weeks, and so these happen to be in the time period when he wasn't deleting them. So these would be the 2 weeks that he had on.
And when?
Yeah.
What's the date that he provided them?
I'm sorry.
He's providing his personal calendar electronically from January 22, 2016 to March 30, 2016. What is the date he provided it to the staff?
These were provided to the Sunshine Ordinance Task Force. So
all right, to the task force. Do you know the date he provided it to the task force?
At some point, Mr. Cava started retaining his electronic records, and so he wasn't deleting them anymore every 2 weeks, his electronic calendar. And I'm not sure when he provided these to this task force, but these are for the new period of time. Now, going forward, he's not deleting them anymore.
So he is presently keeping.
Yes, that is my understanding.
Presumably for 2 years.
I'm not sure how they're interpreting their retention policy and whether or not that means they keep them for 2 or 4 years. Yeah, I believe he'll be speaking next.
The other question I have, maybe to shorten this, what do you do? I mean, what is it? You reconstruct the 2015 calendar, his calendar? How? I mean, it's all blank. Is he supposed to reconstruct it?
Right. And that is
that's the theory.
Exactly, that's the theory. Once they're destroyed,
okay,
we don't really have any authority over whether or not the destruction itself was a violation of the Sunshine Ordinance.
And the commission's made no order, obviously, but the theory is that he can go and reconstruct it. A year later, a year and a half, okay.
Go ahead.
I'm really learning how dysfunctional this body is this evening, and
Why don't you present your claim?
Here we go again. Here we go again
You know,
with
Mr.
you guys
Mr.
interrupting.
Petrellis,
You asked me to make a
Petrellis,
5-minute presentation.
Excuse me, Mr.
I'm trying to
Petrellis.
make a 5-minute
Mr.
presentation,
Petrellis, you're
and you
your
keep
own
interrupting
worst-
me.
you're your own
You are
worst
your
enemy.
own worst enemies for
You know, I
years of
started off-
dysfunction at this commission. I would like to finish my 5
Don't you
minutes
want
of
to convince us?
presentation.
Don't you want to convince us? We're the body you have to convince.
Whoa, I didn't know I would be on trial today by you attorneys, and I think...
You know, you came in here, and I had looked at this, and I had read this, and I said, he's got a good point. He's got some... Once again, you're talking me out of going along with it just by virtue of your complete inability.
May I finish? May I finish? You will have plenty of time after I get my 5 minutes to engage in your trashing of the public.
Hey, you're finished. On this one, you had me to begin with. You just lost me.
To get a public document out of the mayor's office at times requires an incredibly thick skin, and it requires a lot of tenacity to pursue just a complaint with the Sunshine Ordinance Task Force, even more tenacity to follow the complaint to the Ethics Commission. Every step along the way, there is dysfunction. A lesser public sunshine advocate would have given up a long time ago. The bottom line of my complaint is that Steve Cowa, the mayor's chief of staff, was destroying public records. You have heard me read from the Good Government Guide prepared by the city attorney, giving his blessing to the immediate destruction of numerous public records. This has been going on for years. You here at the Ethics Commission and at the Sunshine Ordinance Task Force are well aware of the terrible state of records retention here at City Hall, and then what the public has to go through to actually obtain those records. We do not have a friend in the city attorney's office. I have learned after years of monitoring this Ethics Commission, public sunshine advocates do not have friends here. You want to say my bad breath is the problem? Go ahead, I've heard it before. I'm here to say the mayor's chief of staff, Steve Cowa, who's basically been running City Hall for about 20 years, has been destroying records and doing so with the city attorney's blessing. I believe you commissioners had a duty to go over the voluminous records before showing up tonight. And I believe you have to get back to some decorum where you respect the public and the complainants and allow us to speak without being interrupted.
Thank you. I understand there's someone here on behalf of Mr. Kawa.
Hi, I am Steve Cava from the Mayor's Office.
All right.
How are you, Mr. Chairman, members of the Commission? I would say I'm happy to be here tonight, but I don't know if those are the accurate words, but I do think it is going to be informative for not only me, but for the other 30,000 city employees. This issue was brought as a complaint by Mrs. Petrellis regarding my calendar to the Sunshine Task Force. I, yes, have been in the Mayor's office for 20 years, nearly 20 years, and City Hall for 25. I take my job quite seriously, and I take my obligations quite seriously. Every year we have a session with the City Attorney's Office regarding records retention. And one issue that comes up every year is calendar. I'm sure you're aware about Prop G calendar, where this first complaint came at Sunshine Task Force because I was a department head. I'm not a department head. I'm not covered by Prop G. I'm not an elected official. I'm not covered by Prop G. And so then they morphed it into another issue. In those sessions with the city attorney's office, this issue comes up with staff. What do we need to retain? Because we will retain it. When it came to calendars, it was Prop G, mayor's calendars for the mayor's office, not staff calendars. And so it was my practice to keep it for 2 weeks and then move on. And that's why, Commissioner Kopp, you see what you have there. The Sunshine Task Force asked me for what I had, and I gave it to them.
When did you give it to them?
Well, when this first arose, Commissioner Kopp?
Well, approximately.
Yeah,
This year, right?
I think it's in February.
Yeah.
I don't recall.
The
exactly.
last one is, I don't know, March 28th or 29th.
Yeah, so,
All right.
and so when this appeared before the Sunshine Task Force, it was amazing to me how much confusion started to exist about whether or not the advice we were getting from the city attorney's office, not me, but city employees, was the right advice. And the Sunshine Task Force, I guess, was saying it wasn't. So I've been keeping my calendar, because what is the correct process here? In watching this process tonight, I'm going to really ask you all as the Ethics Commission to help all of us in this city, in city government, and city employees to understand the process. Because I was following it. And now I'm here before you tonight. Once again, not for me, because I know I did the right thing, what the advice I got, but for other city employees who are watching this or hearing about this. So I'm happy to answer any questions.
Well, once the complaint was filed, have you, since that time, kept your calendars?
Yes, because I didn't know what the Sunshine or Ethics or somebody else was going to say. The advice I've been being given was not the right advice.
Now, what kind of information did you traditionally put on your calendars?
I think Commissioner Kopp and you all have a copy of, pretty much that's my calendar. And if you can see, there's a lot of repetition on it. I am the chief of staff, so you see a lot of staff meetings. The title goes with the job, and the job is working with the staff.
Go ahead.
Yes. I think, Mr. Cower, you've been acting in good faith, but I think that the city attorney, has been misadvising you. To that extent, I hate to say it, but I agree with the gentleman who spoke just before you. Because just in regard to a number of the references, and I'll reference a couple of things, including the memo that was sent to us by Elena Schmidt in regard to the fact that the Public Records Act here is being parsed much too strictly and through too many avenues and meandering to have any value. But the one sentence I see here at page 3 of the report from Leanne Pelham of September 16th, on page 3, the last paragraph says, the city attorney agrees that Mr. Cower's calendar is a public record, but then argues that Mr. Cower's calendar is not a city record. I don't know what the heck that means. I mean, that becomes an exercise in absurdity. I mean, what we want is as much transparency in regard to the way city government is run. Calendars, particularly of someone of, even though you're not a department head, you're a major official in the mayor's office in regard to so many things that are coming your way, that the citizenry and the public is entitled to know about it. And therefore, in my opinion, that under all of the Good Government Act, not the Good, the Open Records Act and the Transparency and the Sunshine Ordinances, those calendars should be maintained. I also agree, again, very reluctantly with the gentleman who spoke before you because of obnoxious and counterproductive manner. He's correct that the San Francisco Good Government Guide is not law. It's purely a matter of the city attorney's office giving their impressions and opinions. And it's entitled to great weight and great respect, but to cite it as law for something, and we've seen this before, and I made this comment before, it's inappropriate to cite it as law. But I think you haven't done anything wrong. I commend you for the fact that when this controversy began and you saw this could be a problem, you then started maintaining your calendars. I commend you for doing it. And I think the city attorney should revise its advice to city officials and to city government employees to make it much more expansive in regard to what is indeed a public record that needs to be maintained.
If I might respond, though, in a sense, why did you have Proposition G, which specifically identified who had to keep calendars? How does other city official or a city worker know his calendar should be kept when the only basis for calendars as against the Board of Supervisors and the mayor and elected officials and department head was Prop G? I mean, it causes, as I read it, it caused me to say, clearly nobody contemplated personal calendars being kept. I agree, it might be a nice thing for somebody in Mr. Cava's position who's certainly in a powerful position. But how is he or anybody, why would they think they had to keep their personal calendars when you've got a special statute that provides for who has to keep calendars?
Well, because
and then the balance of the calendars would be dealt with by the records retention policy.
Yeah.
Right. For those who are not subject to Prop G,
right,
their calendars would be dealt with on the basis of advice from the city attorney's office as to what should be kept and what should be disposed of.
And could I respond to some of the comments, if it's okay? Commissioner Keene, to you, I mean, exactly. You were talking about staff recommendation and saying that this person here said that they are records, but the city attorney was telling us they're not records. So clarity would be great, consistency even better for everybody who works for city government, from authorities like the Ethics Commission, the Sunshine Task Force, and the city attorney's office, because I think it would benefit all of us. And as Chairman Rennie said, Prop G was passed by the voters for the mayor and some other elected officials. It was amended later to include members of the Board of Supervisors as well as department heads. It can easily, Commissioner Kopp, be amended again, I think both legislatively or by the voters, to include more folks. Folks like myself would be happy to comply if we're told to comply. In this case, I wasn't told to comply because I didn't need to comply to the law. And so that's the sort of what good can come out of tonight is if we could get everybody together on behalf of folks, on behalf of transparency, and say, for instance, the Ethics Commission, your own records retention puts it into Category 5, calendars. You don't have to retain them in the Ethics Commission, except Prop G for the Executive Director. So be consistent with your own staff as you are going to be with all of us.
If I could just say something, thank you for acknowledging the confusion, but generally I think that everybody agrees that these calendars are public records, and that the definition of public record is so broad that there are so many things that qualify as public records, which is why the records retention policy is very important, and it's important that people follow the records retention policies that their own department heads set up, because it contains a list of every single document, what category they are, and when those records can be destroyed. Because even if something is a public record, that doesn't mean it needs to be retained in perpetuity. We all can destroy certain things, even some things you wouldn't think should be destroyed can be destroyed, because the sheer volume of material that we would be retaining in perpetuity isn't possible. So there has to be some sort of orderly management to how government functions, and that's why the Sunshine Ordinance and the records retention policy are designed to work in tandem. If the records are retained, if they aren't being destroyed, if they're not something scheduled to be destroyed and already have been destroyed, then you can have them. If the public wants them, you can request them, and the public gets them. If it's something that happened many years ago, if it's something of a personal nature, if it's not a record at all, which is a very small category of information, then that's not available to produce because it doesn't exist. So that's the general and broad public policy behind the system. Now, the fact that the Sunshine Ordinance doesn't incorporate the records retention policy does present a problem for if somebody violates the records retention ordinance and somebody wants access to records that were deleted, right? I mean, that's the exact situation that we have here. The issue that we have to grapple with is whether or not who has authority to do something about that event. Okay, and the Ethics Commission has very specific provisions set forth in its charter and very specific provisions set forth in the Sunshine Ordinance for when it has authority to act, and when and the absence of authority to act means there is no authority to act. So declaring that something is a public record, declaring that someone violated a retention policy, that's subject matter for the retention ordinance, not the Sunshine Ordinance, unless it's in two categories. There are two instances where the Sunshine Ordinance speaks directly to retention of records, and that's Prop G, as the chair correctly pointed out, and then the department heads and the mayor personally themselves have to retain all of their records. So the Mayor Edley, cannot delete anything, really. I mean, he can't delete anything because he's supposed to maintain all of that for transition of office for the next person who comes in. Those are the only two situations where the Sunshine Ordinance itself contemplates retention. The rest is all under the ordinance. It's all up to department heads and management by the city. And if there's a willful violation, if somebody willfully violates the law, destroys records to prevent the public from getting them, that goes to the district attorney because it's a crime.
Commissioner Kopp?
Chairman, first, that suggests some work for you in preparing and recommending legislation, and then I guess we recommend it to the Board of Supervisors. And, Mr. Chairman, I would urge that that be done. I don't want to step on the executive director's toes or the chairs, but in any event, that's clear. Secondly, relevant to that, there were some questions. There's also a question raised on page 8 of a report from the Sunshine Ordinance Task Force. And I guess I've got to have somebody not here, not now, explain to me why the heck there is a Sunshine Ordinance Task Force, why it isn't part of an Ethics Commission. But that'll come from...
You'll have to find a former supervisor, Shelley, who drafted the thing.
Oh, is that right?
I think that's where the Sunshine Ordinance originated.
Yeah. Well, I think I'll ask Mr. Brugman, because I hear about the Sunshine Ordinance Task Force from Mr. Brugman all the time. But on page 8, there is a footnote saying the ordinance is willful violation of dead letter. We believe the Ethics Committee or Commission should amend their definition to encompass such reckless action to cover the circumstances of this matter. And I would like that examined legally in terms of propounding an ordinance for adoption, because it is naughty to try to make a finding as to whether conduct there was willful or reckless. Thirdly, I'm curious, and the claimant can answer this, as whether he's taken this to the district attorney. I see a reference on page 7 of that same June 30, 2016 order of determination to the District Attorney's statement, January 22, 2016. All I can tell you is we've been investigating irregularities in local government for quite some time, which is a possibility. And lastly, on a memorandum January 8th of this year from a Jerry 3, Deputy City Attorney, he raises questions, Mr. Cava, about the questions that might assist in determining facts. Now, I know this may be a bit repetitive, but he says, does Kawa personally delete his electronic calendar entries on a rolling basis 2 weeks after an appointment has been completed? And the answer to that was, past tense, yes. Is that correct?
To be absolutely accurate, I personally do not. I have an assistant.
But somebody else does
it's not Mr. Cava.
Yeah, someone does it for
at
you.
that time, as I say it.
And is any physical copy of the calendar printed to maintain the deleted entries?
Not to maintain.
And there is none. If not, how would Kawa reconstruct his meeting schedule at a later date if that became necessary, which I asked a little while ago? Is this a policy of the mayor's office generally or particular to Kawa? And the answer to that was particular to you?
Yeah, it's people have their personal calendars or their calendars, the staff, and so.
But was it a policy?
No,
policy means writing to me.
Oh, no. Once again, we had sessions with the city attorney's office.
It was up to you.
Yeah.
All right. And so the record is relevant, and you have changed your custom and practice, so now you're retaining them.
Yes, to see the end of the process, to see what really is. I've been following the process. I've been following the advice.
But you're retaining, and you gave us examples for 2 years.
Now, so you mentioned the 2 years earlier, Commissioner Kopp. That 2-year retention is in regard to Prop G calendars, I believe. Prop G says 2 years. And once again, and I am sorry to correct you, you can't say it's a public record. If you are, you're saying that the Ethics Commission also wants to get rid of public records because your records retention says calendar, Category 5, doesn't need to be retained, Prop G for the department head.
But the city attorney does say it's a public record. That's what I just. That's what I just.
Is it a public record? But it does not have to be.
So
retained.
under Sunshine, if you have it, you have to give it.
All right. Just to eliminate future disputes and arguments taking up staff time, our time means nothing. The song, your time is my time. 2 years seems to be a standard. Would you agree?
Prop G says.
Yeah. Well, also I'm thinking about a case in L.A. First Amendment Coalition is pursuing that I think led the L.A. City Council to say 2-year retention because some guy left the council and burned all his documents. All right. Anyway, it's going to be some period of time, a year and a half, 2 years. And that ought to be identified and nailed down in law or regulation. And all right, the rest of it is simply a part of this allegation and this claim. But those are my concerns.
I have a question for the city attorney, just to clarify. There are many public records, but not all public records need to be retained.
That's correct. So, and just by the way, I just wanted to give the commission the background, which is that within the city attorney's office, we maintain a due process screen in all enforcement matters, meaning that I have no communication with other people within the city attorney's office about this particular matter. And the purpose of that is so that I can give the commission advice that's not impacted by the advice that other deputies have given to their clients who may be here. So that's just for some background. I know that my colleagues, for example, one of them, Buck Delventhal, has written 2 memos to the commission. I have read them, of course, because they're part of the public record, but I played no role in drafting them. So just so you know where I'm coming from. So yes, documents that are created by city employees in the course and scope of their jobs are public records. Whether those public records must be retained and for how long is answered by the Records Retention Ordinance, and that
which is separate from the Sunshine Ordinance.
That is separate. Now, that's not to say that the overlap would be in a circumstance where, let's say that you've created a document that could be promptly destroyed under the Records Retention Ordinance. If someone had filed a request for that document, you couldn't then delete it after receiving the request, and that's what 67.21 says. Every person having custody of any public record, shall permit it to be inspected. And so, if you had a circumstance where Mr. Petrellis had requested a document from Mr. Cava, if he deleted it after the request, that would violate 67.21. As I understand it, the evidence here is that's not what happened, that these were deleted, the documents at issue were deleted before the request. And because they were deleted before the request, the question is really, did that deletion violate the Records Retention Ordinance? We believe the answer to that question, I believe the answer to that question is no, and I agree with Buck Delventhal's analysis on that question. But for purposes of the Commission's consideration of this complaint against Mr. Cava tonight, there are 2 questions. One of them is, did he violate 67.21? The answer to that is no, because there was no deletion after receiving the request. And then the other provision of the Sunshine Ordinance that's at issue is this one, 67.29-7. And that provision says, the mayor and all department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence. Now, one could get into some interesting discussions about what does it mean to maintain something in a professional and businesslike manner. That's an issue for another day. The point here is that provision applies exclusively to, as the ordinance says, the mayor and all department heads. And since Mr. Cava is not either of those things, that provision doesn't apply. The broader questions around should record retention laws be changed within the city, should there be different enforcement powers, those are interesting questions that the Commission could certainly take up another time. But for purposes of this complaint, our view is that neither of these 2 provisions of the Sunshine Ordinance that are allegedly violated have been violated here, because by their plain language, one of them doesn't apply to Mr. Cava because he's not the mayor or the department head, and the other doesn't apply because there's no question that he did not delete documents after receiving the request from Mr. Petrellis.
Who's the head of the department? The mayor?
The mayor is the head of the mayor's office, yes.
I just wanted that for the record.
Well, one could argue in terms of the definition of that. I know that's the point you were making in regard to where you say the mayor, and you have someone in Mr. Cava's position who is such an integral part of the entity of the mayor.
Could define it in law.
Sure, or just the way the law exists, and that's why, in regard to, even if we go along with your argument, then I see it. Your argument is a logical one as you go in terms of, well, it's not, he's not specifically listed. In terms of all of the policy considerations, the good government, open records, policy considerations, transparency, it would be, at a minimum, a very beneficial thing if someone on the level of Mr. Cava and others in those positions did maintain those calendars, and it were mandatory that they did, that they knew that they should, because it's tremendously valuable to the public and to citizens. Everyone here agrees with that. And again, I'm commending Mr. Cowan. I'm only one member of this commission, but you're saying you're listening to us and you're seeking guidance, and I'm tremendously grateful for that. I'd encourage you to continue to maintain it, even though I may be. I couldn't get a consensus around the idea that there may be some obligation on you to do some specific obligation under the language that we've parsed our way through to do it. I think it's commendable that you are maintaining it, and I hope you continue.
Absolutely, Commissioner, and particularly since what I hear from the Commission tonight, that you appear to want to be helpful to the rest of the city family about getting clarity and having these questions that you're asking tonight answered, that it's on a piece of paper so people understand it, everybody understands it. You don't need to hire an attorney to interpret what your responsibilities are, that when you see it, you know it. And I think that's all I could ask.
But am I correct in understanding what you're saying is that every piece of paper that is prepared during the course of their duties by a city employee is a public record?
Generally, yes.
Yeah, as a general rule. And that the question of whether or not that employee who may make a note to him or herself, whether or not they can destroy it, is up to whatever department it is, what their retention policy is, as stated by the department.
Yes.
And who reviews the various retention policies to determine whether or not they're complying with the Brown Act, any Open Government Act, any of them?
Right. I mean, I think that the discretion is each department's to create their own policy. I mean, that authority is vested in them by the particular legislation, the records retention policy. So I'm not, I mean, what would happen if a department said, we will not be retaining any documents whatsoever, period? I think that, we'd have to just sort of deal with that down the road. But certainly each department, in consultation with the city attorney's office, does create its own
I take it
policy.
The city attorney advises all of these agencies if they ask for guidance.
Commissioner,
it's our policy, yes. Right. If I could just make one point in response to to Commissioner Keene. I mean, on the question of the wisdom of retaining calendars, that's of course not that's beyond my pay grade. But I think that within the Sunshine Ordinance, there are circumstances where, when the ordinance targets a particular employee or category of employees with responsibilities, it's generally specific, right? Does a particular provision apply to an employee? Does it apply to the department head? Does it apply to the mayor? There are all these different categories that are specifically enumerated, and so I think that it's not. I think it would be sort of an overly broad interpretation to look at the term mayor in 67.29-7 and say, well, the mayor also refers to, other people within the mayor's office beyond the mayor, such as the chief of staff, because there are, again, circumstances in the Sunshine Ordinance elsewhere in different provisions where the ordinance is very specific about who has particular responsibilities. And so the fact that the mayor's chief of staff is not included within 67.29-7, I think is evidence of the intention of the voters and the Board of Supervisors, both of whom have amended the Sunshine Ordinance, that this provision does not apply to the chief of staff.
You can cure that amendment.
If that was a question, yeah, I mean, sure, the Sunshine Ordinance can be amended, as can the records retention law. as can document preservation.
Do we have the power to ask you to prepare such or draft such an amendment?
Well, I think that because that has not been separately agendized as a discussion topic, I think we should reserve for another meeting the question of what laws the commission would like to change. For tonight, I think we have to confine ourselves to the one question of whether this respondent has or hasn't violated the
Can I ask Mr. Pertalis a question or two? As far as you know, were there any documents that you requested that were in existence at the time you requested it that were destroyed subsequently?
I do not know. I cannot say.
So that the heart of your complaint is that back in September, October, November, December, which was the time period you were asking for calendars, that Mr. Kawa had this practice of eliminating every 2 weeks. And that's what you are complaining about in terms of compliance with your request. Is that correct?
Right. My recollection is that in the mayor's response to the Sunshine Ordinance Task Force after I had filed my complaint, it is in the mayor's office response that it is disclosed that Steve was destroying the records.
Right. Right. But it's the records that no longer existed at the time you asked for them that is the basis for your complaint.
Correct. Correct. And just on a technical or mechanical matter, it's come up at the Sunshine Ordinance Task Force whether or not the servers, the disks, I'm not sure what the right term is technologically, even if it was deleted, let's say, from his Outlook program, would the data still be on a city hard drive, a city server somewhere? That question was not answered as far as I can remember at the Sunshine Ordinance Task Force. And I think it's important to address that.
Did the Sunshine Ordinance Task Force vote to ask that question? I'm asking you. You were there.
My recollection is no.
All right. Do you want to ask for it?
I would urge you to ask for it because it gets to the heart of the matter.
Hold it. Then may I propose that we send a letter asking for it? See if it's on the hard drive or some other.
You mean if there's somewhere in the city server that it preserves the thing?
Yeah.
I'm certainly happy to send and ask them. The question might be how expensive it is to try and find it. I don't know.
Yeah.
I don't know.
Well, ask that too. Yeah,
Ms. Bloom, do you know the answer to that?
I think that you could probably ask whatever question that you want. Is my answer. If you wanted to ask the city attorney's office if they retain those records on a hard drive or a backup disk somewhere, I guess you'd have to ask the mayor's office directly. Maybe I don't know if the city attorney would know, but you could probably ask a question. It wouldn't be in the form of an order or anything. It would just be a question. I think that you can do that.
Well, I guess, Commissioner Kopp, I would say that the answer to that question is probably not relevant to the question of whether Mr. Kawa had violated or the mayor's office violated.
I suppose, but the object is I'll call it truth. The object is the document, and I wouldn't let that bar obtaining the documents for whatever reason he wants them.
Did you have?
I think each department has its own record retention policies, and I don't know off the top of my head when a mayor's office employee deletes something off of his personal Outlook server, where it goes. That's a question I just don't know the answer to right now.
I've been told that the Essex Commission doesn't retain anything on backups. We don't have backups. There's not there's not enough room on the city server, so we don't have backups of our material.
Let's cover it so that we've exhausted every remedy.
I'm Charles Marsteller. For the record, I wanted to tell you I talked to one of the techies I know, and they said it's likely, given the time frame, that not likely, it could well be possible that given the timeline, and I explained the timeline, that the document may exist on the people that maintain, in the files of the people that maintain the mainframe of the computer. So it used to be the Department of Information Services or something. They've changed their name several times. But the question for this body is whether there's a role to publicly state that it's to the interest of this commission that those documents they are of interest to this body and that they be preserved. I don't think you have to formally issue a subpoena for them or anything like that, but because Mr. White, I believe it was, made a reference to the retention laws and cited a section about the destruction of information once the question was raised or the documents were requested. It might be that you want to go on record in some way that these are critical documents that should be preserved effective this date, so that there's a statement on the record that under the state retention policy that then parties of interest would know that those documents should not be deleted or destroyed. I don't know if that would require you invoke a subpoena power or not. That's a technical question, I guess, for the city attorney. Thank you.
Yeah, I share my fellow commissioners' interest in understanding whether or not these documents still exist, but I would like to note that Mr. Cava and others have acted in good faith and reliance on the retention advice received from the city attorney and deleted those documents. Now, if we were to go back and conduct some technological forensics to be able to resurrect them, are we opening up some issues with regard to, what's the right word? With regard to the ability of employees to rely on advice from the city's attorney's office, and then what then constitutes the definition of a retained record?
Mr. Chairman, may I make my proposal and motion clear? And that is the chairman be authorized with a letter drafted by staff, whoever wants the honor, to ask the relevant city department if it can recapture the requested records for those 3 months or 4 months that were requested. No more.
I don't know if that was in the form of a motion or is this?
Motion.
Second.
All right, any comment of other commissioners? Or we call the vote? Any public comment?
Well, can I just make one quick point? I mean, I think Commissioner Chu is correct that I don't think that there's anything that precludes you from sending that letter. I also think that it is separate from the question that exists of whether Mr. Kawa has complied or not.
We'll deal with that after the vote on this motion.
Oh, okay. Fair enough.
Yeah,
I just wanted to make clear.
And I would just like to say, in seconding Commissioner Kopp's motion, I totally agree with Commissioner Chu that in terms of our curiosity about whether or not this material still exists does not in any way cast light on Mr. Kawa's good faith as I see it up till now. It's I think we've dealt with that. And it's not in any way a witch hunt after him saying, well, we can get them now because they destroyed it electronically and it was after it was asked. I would never go there. So you know.
I guess even beyond that, I think the good faith or not speaks to the question of whether it was a willful violation. And it sounds like there's agreement that it wasn't a willful violation. I mean, even beyond that, there's the question of whether there was a violation of the ordinance, even a non-willful violation of the ordinance. And the fact that the documents may or may not be in some cloud backup somewhere doesn't, I think, bear on the question of whether there was actually a violation here.
Public comment?
Ray Hartz, Director, San Francisco Open Government. It is simply amazing the time, energy, and resources the City Attorney's Office will expend to ensure that city officials do not comply with open government laws. The City Attorney advises people willy-nilly, and we've heard examples tonight, that basically every department can decide what they want to keep, what's a public record, what's not, how long they keep it. And basically what you're saying is the citizens can't rely on anything. Since anyone with half a brain already knows the outcome of the hearing, I would suggest Mr. Petrellis refile the complaint naming Mayor Ed Lee. The mayor, an elected official, is responsible for ensuring that those under his supervision comply with the law. And basically 6724 says that any person failing to carry out acts that they are obligated to follow under this law, the Brown Act or the California Public Records Act, is guilty of a misdemeanor. Despite all the shucking and jiving in these laughable legal memos, it would seem the members of this commission seem determined to remain willfully blind to the fact that someone as senior as Mr. Cava would have known his actions were questionable, if not unlawful. I see his machinations as nothing more than an effort to hide matters that potentially could be embarrassing for Mayor Lee. The reason I say this as a member of the public, we don't trust the government anymore, especially me and the city government. You could basically bring things to the city government, you ask them to follow the law, and they refuse to do it. I asked for records from the San Francisco Public Library, and it took 2 years to finally get the records. I twice petitioned the city attorney's office to send it to the district attorney and the attorney general. Both petitions were denied, even though they took 2 years to produce the records. And I actually have a violation against the city attorney's office for acting as counsel for a city agency trying to withhold public records. When we brought the case on which those records, in which those records were used to the Ethics Commission, Ethics refused to deal with it, and we took it to the FPPC in Sacramento, and the city librarian, Luis Herrera, was found to have violated the law by filing statements of economic interest for 3 consecutive years, stating he had received nothing from a particular group, although he had to go back and restate that he had gotten $5,000 a year worth of stuff that he knew he was supposed to declare. He signed those statements under penalty of perjury. So it's really interesting that the city attorney has done such a deal that everybody in the city, including Mr. Cava now, can come here and say, oh, we're poor city employees. We don't know what's going on because everybody's so confused. And why can't we rely on the city attorney? Well, the city attorney gives everybody different advice, apparently. He says, well, if your rules say this, you can do that. And if the rules don't, you can't.
Thank you. Any other public comment?
I'm Dr. Derek Kerr, and I'm not an attorney. But what's striking about this case is that the mayor's chief of staff deleted his calendars every 2 weeks, methodically. That takes effort and discipline, either by him or a subordinate. Many busy people keep appointment calendars, but few of them erase them so quickly and so diligently. It seems like a taxing chore to do this, even for the most fastidious of persons. But because the mayor delegates important tasks and appointments to his chief of staff, this commission should consider whether furtive purposes drove this behavior. Even if there was a policy or a practice to promptly delete appointment logs, what is the underlying rationale? Does it save money by preserving space on computer hard drives? Does it reduce the workload of the Information Technology Department? Or does it intentionally conceal activities of public interest? Thank you very much.
Thank you. Any other public comment?
David Pilpel, there's a lot that I could say on this topic, but I'll try to be brief. I was a member of the Sunshine Ordinance Task Force. We heard this matter, I think, on 3 different occasions. In response to Commissioner Kopp's question, I believe that the undeleted calendars were provided to the task force in connection with the April 2016 meeting. At the March meeting, we asked if they were changing their policy, could we see some examples of calendar entries subsequent, and those were provided. Just a number of different things that I'm thinking about. When the original Sunshine Ordinance was passed in 1993, it only dealt with public access to meetings and records. It was really an effort of Bruce Brugman's with then Supervisor Achtenberg and Supervisor Shelley that really sought to enhance the public rights relative to meetings and records beyond what was required in the Brown Act and the California Public Records Act, both of which I think then Senator Kopp had positive amendments to in 1994, if I recall correctly. Further, in 1999, when Prop G was being drafted, I was part of some of those discussions, and there was an interest in enhancing some of the rights, some of which happened in Prop G and some of which got a little muddied, as we've seen over the past period of time. But there really was an effort just to amend the ordinance, and understanding that records retention was already handled in Admin Code Chapter 8, and not to really get into that, both because of the single subject rule at the Board of Supervisors relative to amendments, but also because it really was about public access to meetings and records, not record retention itself. To the extent that it was referred to, it really was in 29-7, which just kind of re-emphasized the need for proper records retention and good business practices around that. Since I see my time is running, I had the minority viewpoint at the task force. I believe that there was a violation of 67.21. I did not believe there was a violation of 29-7, nor did I feel that it was willful, in part for some of the reasons that you've already talked about, because there was reliance on advice of counsel, because the mayor's office was willing to change their record-keeping policy and retain records going forward. In summary, I still don't believe that there was a willful violation. To the extent that there was any violation, I think it's de minimis. I think we're really talking about what's the best course going forward. I believe that it's very clear that department heads and elected officials need to maintain a calendar under Prop G, the 29-5 requirement. To the extent that other city employees maintain a calendar evidencing their efforts, I think they should keep them for 2 years. They're not required to keep them, but to the extent they do, I think 2 years is an appropriate time. Unless you have questions, thank you.
Any other public comment?
Thank you. Hello, Michael Petrellis. I very much am in favor of this letter that you want to send regarding.
You don't have to take public comment.
I think you've had plenty of comment, but.
Okay, I'm confused. We're talking about the motion for the letter about 3 months, right?
Yes. And you said you're in favor of that motion, right?
Yeah.
I think you've had plenty of time.
I want to stick. Well, is this public comment on the motion or not?
You have to take public comment once per agenda item, and you've already done that, and he's already spoken, so it's your discretion about whether you would like to give him another opportunity.
Say, be short.
Are you in favor, or yes or no?
I am very much in favor of getting more information about the mainframe and how long records and data may be on there. And I hope that one day everyone at City Hall above a certain level on the mayor's staff and all elected officials who are required to keep a calendar, that we have a web page through the city's website that is automatically disclosing those calendars once a month, so there is no burden on the public to request them and go through what I've had to go through to get those records.
Thank you. I will call the question. All in favor of Mr. Kopp's motion about my sending a letter to get further information as to the availability of the documents?
Aye.
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 Opposed? All right. It's carried unanimously. The main purpose of item number 5 was to respond to the referral from the Sunshine Ordinance Task Force that found that Steve Kawa, Chief of the Staff, Mayor's Office, in violation of Administrative Code Section 67.21 and 67.29-7, and further finds the violation of Administrative Code Section 67.21 as a willful failure to discharge his duties under the Sunshine Ordinance pursuant to Administrative Code Section 67.34. The staff has recommended in its memorandum that the Commission find that the Sunshine Ordinance does not require Mr. Kawa to retain his electronic calendar, and that Mr. Kawa did not violate the Sunshine Ordinance by failing to produce his electronic calendar to Mr. Petralis. And it is a proposed order for the Commission's consideration. And do I hear a motion as to whether or not we support the recommendation of the staff?
So moved.
A second. Any discussion?
Can we break that down into 2 parts?
Yeah.
Because it is actually 2 parts in terms of whether or not under the Sunshine Ordinance laws, one would be required to keep the record. I know I'm brutally misphrasing it, and then there's another one as to whether or not there was any willful action in violation of it by Mr. Kawa. I still have some.
I would second that observation, which I interpret as a motion to amend.
Yes. If we could break it down into 2 parts. And
Well, do you want to state your amendment for the record?
That the retention of Mr. Kawa's calendar was indeed required by existing law, and I wouldn't go any farther than that.
All right, I'd second that as a motion.
And are you withdrawing your motion?
Yes.
All right. I've got to say I will vote against it when it comes up, because I don't understand what it is that you're pointing to that required him to keep them.
Mainly what I'm pointing to is the overall collective aspect of the Sunshine Ordinance, Good Government, Brown Act, and in regard to public records, the city attorney's interpretation of this particular calendar as a public record, and the underlying requirements within those ordinances and the policies that speak to those ordinances, that those things should be preserved. I know it's I'm casting a broad net here. And I know I'm doing it in a vague way, but I think rather than just give a pass to the whole idea that records of such moment and significance as the mayor's chief assistant's day-to-day records of what's going on in the mayor's office can just be trashed. I have difficulty under the laws that we have relating to sunshine and transparency. I have difficulty with that, and that's why I'm proposing my motion.
Chair Rennie? Under the Sunshine Ordinance, I don't believe that there was an obligation for Mr. Cava to retain his calendar because the ordinance incorporated Proposition G, which specifically enumerates those people, the mayor and elected officials, as well as department heads who needed to retain their calendars. And since the ordinance and the proposition were so specific as to the people who were to be subject to this requirement, and that the chief of staff in the mayor's office, although he is a very important and major person who is responsible, has great responsibilities, he is not included in that list. I don't think that under the Sunshine Ordinance that there's been a violation of the records retention, the records retention policy.
That's why I made my motion so general and just said that there is a legal requirement that under law those records should be retained, because I would accept your statement that on the face of it, it's hard to pin it down unless we go to what Supervisor Kopp and I started to have a philosophical colloquy about. What is the mayor, and what is the entity of the mayor, and does it broaden to the extent of Mr. Cowell? I don't think we need to be that philosophical, but I'm troubled that just in the same way that some of the people have been. The doctor was troubled about the idea of such an important piece of governmental information like this just being discarded routinely, and what some of the observations of Friends of Ethics and Ms. Elena Schmitz asking us not to parse this so specifically in regard to the particular language of the specific ordinances, that we should send a message that this is an area that the public and the law does require the material be maintained so the public knows what's going on in some place like the mayor's office.
Okay, I'll call the question. All in favor of the motion?
Aye.
We've had comments on item 5, and I've been told public comments, I only need to call for them once.
Aye.
Aye.
Opposed?
No.
Aye. No. Motion is not carried. So I now again go to the question of the referral from the Sunshine Ordinance Task Force finding Mr. Kawa in violation of the various sections that we referred to earlier, and finding a willful violation of Section 67.21, and the staff's recommendation that Mr. Kawa did not violate the Sunshine Ordinance by failing to produce an electronic calendar to Mr. Petralis.
Mr. Chairman, isn't that contradictory? We've just rejected the notion of a violation, and that makes that disposes of the matter.
No, the original, as I understood, the thrust of the motion was that there was that under the Sunshine Ordinance he was required to keep the calendars, and we, as I understand it, that motion was defeated. We still haven't dealt with the question that the Sunshine Ordinance Task Force sent to us, and that is to find him, either we find that he didn't violate or he did, and he has a right to have us make that determination.
Well, I'd argue that it's inherent in the motion we just rejected.
Yeah, I agree. I mean, I think there's no way that you could find that he had no obligation to keep the record. I mean, that's the only consequence is that there's no violation. I mean, you could have a second motion, but I think that if there's no obligation that he kept the requested records, there couldn't have been a violation of the ordinance.
It's made moot.
I mean, I'm not saying you can't have the motion. I just think it's the necessary consequence of the prior motion.
Mr. Philpott correctly points out that our regulations governing these proceedings require that a vote of 3 commissioners are required to make a finding of no violation. And so to determine that a violation of the Sunshine Ordinance did not occur, you must conclude that based on a preponderance of the evidence, the respondent did not commit a violation of the Sunshine Ordinance, and you have to have 3 commissioners to make that decision.
You have what issues?
You have to have 3 commissioners.
Yeah.
Make a finding that there was no violation.
Yeah.
And the question,
all right. The
there's a
argument
narrower
is
question.
we didn't have
That's right.
3. All right.
So there still is the question.
All right, that's the question.
Right.
It's just wording.
And whether or not we accept the staff's recommendation that there was no violation.
I move we accept the staff's recommendation.
I hear a second. Right.
But I'm sorry, I didn't hear you.
I move we accept the staff's recommendation that in regard to Mr. Kawa, he did not willfully violate the statute.
Oh, all right, I'll second that.
Just seconded already by Ms.
Oh,
Chu. All right, I will call the question. All in favor?
Aye.
Opposed? Staff's recommendation is adopted unanimously. Turning to item number 6, discussion and possible action on amendment to the Ethics Commission bylaws to establish a process for staff to notify the Commission when attorney-client privilege has been invoked in response to a request for public records. Any discussion on this among the commissioners? Hearing none, any public comment?
And you can sigh as much as you want. Ray Hart's Director, San Francisco Open Government. In this matter, I have a couple of comments to make. First, the Executive Director should not only notify the chairperson of the public record request where documents were withheld by claiming attorney-client privilege, but should also include from time to time with that figure the total number of public record requests for the same time frame. In other words, the public should know how frequently records are being denied based on attorney-client privilege. And that is really important because in the Sunshine Ordinance, it basically stipulates that anything having to do with open government is disclosable, even if it is attorney-client privilege. So basically, what we're in this conundrum of is constantly when you ask for documents, they say attorney-client privilege, but the Sunshine Ordinance also stipulates that if you're withholding information, you have to provide a document. It may be blacked out, but you have to say specifically what was blacked out and cite the law that supports it. And unfortunately, in 90% of the cases I have seen, when public records requests are made, it is simply, they say attorney-client privilege, and that's all the information you get, which means you have to take the person who does not want to disclose the document's word that they are being honest. Now, don't turn that into, well, you're saying everybody that works for the city is a liar. I am saying that the reality is some people like to hide things and some people have a need to hide things. Just look at Governor of New Jersey and Bridgegate, where his staff members directed the Fort Lee exit for the bridge to be blocked, resulting in massive traffic jams. So we know that this happens in government, and believe me, with all of the ethics things we've have going on over the last few years, most of the citizens of San Francisco really believe that this city government is corrupt. Not that every single person is corrupt, not every single action is corrupt, but some of them are, and there have been too many things that have happened that have allowed people to keep things secret from the public. I asked for public records. I've got 27 orders of determination, and I won't go through the fact that the Board of Supervisors has used its machinations to undermine the task force. 8 of those recommendations, I had to get 6 out of 7 members because the Board of Supervisors ruled that even though there were 11 members and 4 of the seats were vacant and 1 of the people was sick, you still had to get 6 votes to win. So basically, there are a lot of machinations, and there have to be some efforts to keep this attorney-client privilege something that is actually visible to the public.
Thank you.
I've got a question for this gentleman. Do you have a draft amendment that you would like us to consider? Yes or no? I draw an inference that he doesn't.
You're snotty. You really are.
Mr. Pilpel.
Hi, David Pilpel. I've spoken on this matter before when it first came up. I think it is unusual at best, perhaps unprecedented in the city, for a commission to have these kinds of procedures for reporting public records requests to the body, which were in some cases just addressed to the department head. The department head has independent responsibilities under the Sunshine Ordinance and the Public Records Act to respond timely to public records requests, regardless of whether the attorney-client privilege is invoked. I guess if you're going to pass this, we should see how it works for some period of time, 6 months or a year. And I would presume that all of the communications that result from this amendment, a copy of them would be placed in the public file, the 3-day or the 30-day file. Perhaps they could also be incorporated into the executive director's report so that members of the public also have the opportunity to know what information was presented to members of the commission in connection with these kind of public records requests. I think this was just really dealing with a specific instance that arose from the Alan Grossman matter, and I'm not sure if this broader bylaws change is warranted. So I am fairly concerned about this and not sure that it's the right course. But if you choose to do it again, I think we should have some more public transparency around it and review it to see how it's working. Unless there are questions. Thank you.
Thank you.
Move the proposal.
Second. Call the question. All those in favor of adopting the bylaws amendment as submitted in item number 6?
Aye.
Aye. Opposed? Matter was carried unanimously. We'll go to item number 7, which is a presentation and discussion of informational staff report highlighting 2016 election activities.
Good evening, Commissioners. Jared Flores, our Education and Compliance Officer, was unable to be with us this evening, but I just simply wanted to highlight 2 things for you. One is that we did have a corrected report. We misstated the $2.75 appropriation to the election campaign fund in the first document we issued. We said it was per voter. It, in fact, is a per resident. So we've updated our election report for you. We wanted to just provide this as a way to help people focus on the upcoming data for the election and to drive them to our website and our dashboards that are being updated with every campaign filing period between now and the election. So the staff is working very hard to try and get information out, as well as supporting compliance with those who have reporting requirements with us. Happy to answer any questions if you have them, but I just wanted to draw your attention to the new document that is a summary of some of the key data to encourage people to look at our website.
All right, any comment by any of the commissioners? And Pelham, I appreciate your keeping us updated on that and the work that you and the staff are doing on that. Is there any public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. What is the purpose of this handout? Is it soliciting members of the public to be informants? Of course, you will praise the staff, which you already have, to high heaven producing this meaningless drivel. If this is supposed to promote awareness, Why should the public believe that anything they turn in will receive attention? All the cases this body deals with relating to campaign finance take literally years to work their way through your labyrinthine process. We saw an example of that earlier tonight. Case in 2010, and here it is 2016, and you're finally dealing with it. Most campaign finance delinquents can count on dying peacefully in their sleep before you get around to taking any action at all. The actions that are taking eventually are nothing but a form of manipulative self-gratification. This city has become a cesspool of campaign funds raised by small fish who you will crucify and whales who you wouldn't or couldn't dare touch. And the biggest whale of all, Mayor Ed I Won't Run Lee. What a farce. It's kind of interesting that when you appear before a public commission, they expect and automatically demand respect. I was a member of the U.S. military, and I learned one thing. I always respected the officer that the person I was dealing with, the uniform that the officer or enlisted person that I was dealing with wore. I didn't necessarily have to respect the person. And it's unusual, in my mind, for somebody to sit on a board and commission, be nasty to a member of the public, and then expect that same member of the public to just blatantly stand there and take it. But that's what it seems to be here. When Mr. Petrellis was entering his case earlier, he was interrupted. Even though every hearing I've seen before at this body and every other body has allowed them to have an uninterrupted 5 minutes, the respondent had an uninterrupted 5 minutes, and then questions were asked. I don't think it's unreasonable for someone to come here and expect to be able to say what they came to say without it being interrupted. And posing it as a question when it really is just nothing but an interruption is dishonesty. The father of behavioral conditioning said that any behavior which is rewarded will be repeated. And I've gone to city commissions and boards, and I've got up to say things and been told by people who had law degrees, you can't talk about that. I've got 27 orders of determination. About 8 of them or 9 of them are against people who are lawyers who sat on a board and commission and told me for some reason in their mind I couldn't speak about something.
Time is up. Thank you. Keene?
Yes. Just a couple of responses to Mr. Hart's. In regard to Mr. Petrellis's presentations, Mr. Petrellis's presentations were to a body that he was trying to make a case in regard to, just like you'd be making lawyers making a presentation in court. And in regard to that, us as a body, listening carefully, and I was, and my colleagues were as well, listening carefully and coming to a point in those presentations by Mr. Petrellis where we had a question. It was in his interest, in terms of persuading us, for us to go ahead and ask those questions and get an answer at the time. That's why I was making the observations about him being his worst, his own worst enemy. Separate, totally separate and aside from the other stuff of his political clownishness, which was ridiculous. But I'm talking now to the merits of what Mr. Hart addressed. So for us to be doing what we did with Mr. Petrellis in regard to the questions that I had and what Commissioner Kopp had, my fellow commissioners had in regard to the points that he was raised, it was not disrespectful by us as members of a commission towards the public. It was respectful. It was our saying, yeah, we're interested in what you're telling us. Tell us more, explain it, let us understand it, let us be convinced. And his reaction, stupid reaction, was something that drew a certain amount of ire. I just make that observation to the points you made, Mr. Hartz.
May I respond?
Pelpo?
Further public comment on item 7?
Yes.
I appreciate the handout. I think it highlights some important current factoids related to the election. I really appreciate the work that Jared, Stephen, Johnny, the rest of the staff do on a day-to-day basis, including work on campaign filings and getting good data for the public. I just wanted to inquire about a year ago, Stephen Massey made a presentation to this commission about a totally overhauled website, made a comment about the city attorney having to spend many months reviewing it, and I think Andrew got back at him and reviewed it in about a week or two and signed off on the content. But apparently that new website has yet to happen. So I was very much looking forward to it. I think it provided lots of good information and nifty ways to get at stuff. And I see Leanne is about ready to tell us how soon it's coming soon to a city near us. Anyway, that was my question. Thanks.
I will just comment that we are very much at the staff level, all of us, looking forward to posting our new website, which is imminently sitting on my desk. But we're looking forward to rolling it out very soon.
Thank you. All right, turning to item number 8, which is a discussion and possible action on a proposed biennial conflict of interest code update for Ethics Commission. You want to tell us what that's about?
Yes, very briefly, Commissioners. This every 2 years under state law, local agencies are required to identify and update the positions that need to be listed as Form 700 or conflict of interest filers in their agencies, and they are to also look at the disclosure categories that are associated with each of those designated filers' filing categories. So we have been working with other agencies throughout the city, and the city attorney's been working with the Board of Supervisors to collect all of that data for the city. This reflects for you, for your information and possible action, the updated code as to the Ethics Commission's own list of designated filers and disclosure categories. And they're really the only change in it from prior years is that we have updated our working titles for the staff positions that are listed to reflect the recent staff structural reorganization. We've also added our senior fellow that will be joining our office next week. And so we've gone through the process of having a discussion at the staff level. They've had this information for a month. Should there be any questions that they've wanted to raise or provide any feedback, there has not been any. So we have it on your agenda tonight, both in the interest of making sure that you have, as a body with oversight for our work, the opportunity to approve it. We have also wanted to give the public a sense of transparency about the work that we're doing, including what our designated filers are and what the disclosure categories are. So we have reported this as a preliminary matter to the Board of Supervisors, the clerk's office. This fall, the board, as the code reviewing body for the city and county of San Francisco, will be taking up an adjustment and an update for all city departments. And so this is part of that process, but we wanted to put it on your agenda this evening so that you also could be aware of the process and where we are in it and approve the code before it's finally acted on by the Board of Supervisors.
Asking us to approve the code as spelled out in the attachments?
Yes, as in attachments 2 and 3.
And Director Pelham, so the positions added, those are inclusive of the new headcount that were approved for this fiscal year?
Yes.
Discussion among the commissioners? Is there a motion?
Move approval.
Second.
Public comment?
David Pilpel, 2 things. I appreciate that this is being brought before the commission. I think this is the first time I remember the conflict of interest code for the commission and staff being brought to the commission. I think in the past the executive director has simply made changes administratively to the Board of Supervisors. So this is a significant change in transparency relative to the positions in the code. However, I'm concerned that there are a number of positions being added, and it suggests that a number of these individuals do work, prepare reports and analysis without significant intervening substantive review, which is the standard in the law. I hope that that's not true. In the past, the activities of the staff have generally been supervised by the executive director, the deputy director, or the then assistant deputy executive director, now the assistant deputy director, including the investigations and auditing work, along with the education, compliance, and other activities. So to the extent that this code change suggests that decision-making has been devolved to various people on staff, I'm concerned about that. I just think that it's important that there be the substantive, intervening substantive review by one of the three highest level people on the staff. And I'm just concerned generally in the city that we have, in my view, too many people that are Form 700 filers across the various city departments, whether they're clerks or assistants or others. We've got, literally hundreds of people, some of whom I don't think make the kind of decisions that were contemplated for purpose of being a Form 700 filer, and that has, in my view, complicated the Commission's efforts to require electronic filing of all Form 700. So I guess I would push back a bit on designating additional positions and ask about that intervening substantive review. Thanks.
Thank you.
Charles Marsteller again for the record. I'm speaking really on my own thinking. While we were speaking earlier about essentially enhancing the record retention policy in some way so that it captured and maintained the calendars of a number of people that should have calendars clearly maintained. I said to my friend Elena, maybe we could cut off at SEI reporters, in other words, Form 700 reporters, and put on that class of individuals the enhanced record retention policy if we wanted to look at that in a future meeting. I just thought I would mention it since Mr. Pelpel did a little pushback, which I appreciate. And it has come up in this case. While we have this document before us and we're looking at this question, you might look at some of these people and decide whose calendars you think should be maintained. Are they policymakers, or would the public be upset if these people did or did not report their calendars or maintain their calendars for the purposes of disclosure? So I'm trying to think of a methodology for cutoff, and while we had these names and titles in front of us, I thought I would just mention that. I realize it's a little off topic. Thank you for your indulgence.
Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. Once again, we have an example of resource wasting self-justification. What is the point of repeatedly readjusting the conflict of interest codes when this body has neither the power nor the desire to enforce the law? Case in point, when City Librarian Luis Herrera was accepting thousands of dollars of gifts each year from an outside group and then lying on his statement of economic interest, which the judge seems to think is a funny thing.
What I think is funny is your repetitious
You want to at least be polite enough to stop the clock?
Come on. Jesus.
See, that's what's rude. It's not asking for recognition of the chair, which he is supposed to do, and asking to interrupt me and ask a question. It's just to blurt out like he's still in the courtroom and a judge and can order everybody around. And if you don't like what I have to say, that's viewpoint discrimination, which is a violation of the Brown Act. City librarian filed false SEIs under penalty of perjury, and ethics refused to touch it. It took citizens going to the FPPC in Sacramento to get any result. I sometimes feel I'm watching a reenactment of The Wizard of Oz. The particular scene is where Glinda, the Witch of the North, tells the Witch of the West, "Be gone, you have no power here." I feel pretty much sums up the view of city government as regards this commission. So once more, rearranging deck chairs on the Titanic, you will waste taxpayer resources in an effort to justify your existence. In fact, your very existence makes open government a joke. One of the things that you have to recognize, whether you like it or not, is your reactions to the public are very telling. If you have to be rude to people, if you have to interrupt them not following the regular order when you expect them to follow the regular order, that's a good sign that you've got a bad case. And when you start to object to what people have to say, that's viewpoint discrimination. You may say, oh, no, it isn't, it's just my opinion. Well, you have your right to reply. The Sunshine Ordinance says that any commissioner has the right to reply. But a reaction is not a reply. And throwing mud at somebody or disparaging their comments or disparaging their person is not a reply. It's abuse of power. And that's what you folks like to do. You like to abuse your power by saying, I'm in charge and I can interrupt anytime I want, and all I have to do is make up an excuse to explain it. And when I do, I won't give you an answer, a chance to refute that. I will just put it out there and make my case. I've gone before so many boards and commissions where people told me I wasn't allowed to talk about something that I'm amazed that anybody has any respect for boards and commissions in this city. It's unfathomable.
Commissioner Keene?
I know I shouldn't do this, but I can't resist. Because I've been listening to Mr. Hartz now for about a year and a half. And for the most part, Commissioner Kopp's spontaneous reaction is something that the fact that the rest of us don't constantly do it through Mr. Hartz's presentation shows, I think, great strength of will on the part of the rest of us. Because, Mr. Hartz, it's not a question of interrupting you or not wanting to hear what you say, but for every month you get up 20 times with a spiel that is identical, and you say the same thing over and over and over and over again. Obviously, in all of that cacophony of noise that you make, there are certain nuggets of wisdom and things that would be beneficial for us to consider. And I really try my best to try and pierce through all that fog that you send this way to ferret them out. But it's hard. So I have to see that our newest commissioner's rather human reaction is one that every one of us have wanted to make, but probably have just been we haven't. So that's, since we're having these dialogues back and forth with the public tonight. And we don't usually do it, but we're doing it. And we have the opportunity to do it, and we have the right to do it. I thought I would add my observation to that, Mr. Hartz, because I've been watching you now for a year and a half, and God, you're tedious. You're unbelievably tedious.
All right.
May I respond to Mr. Pilpel's question, just for the point of information for the Commission and the public who might be listening? The reason that we have, I want to assure him that we have not we haven't reached the level of decision-making that he was concerned about. Everybody who is on this list because they have significant independent judgment that they apply in making recommendations directly to decision makers in our organization. And as I read the state law and have understood it, that is one of the factors that would lead somebody to be a Form 700 filer. It is not that they are the ultimate decision maker, but that they have significant judgment and significant responsibilities for shaping the decisions that we make as a staff. I think the other key issue that I feel fairly clear about is that we as an agency who are holding other officials to a standard, we also should hold ourselves to that same standard. So we have broad disclosure categories that apply because of the nature of our work, could potentially affect a lot of interests. So I'm happy to talk with Mr. Pilpel more offline, but I think this is a very accurate description as we currently are structured for the kind of work that people do to shape policies, not just ultimately make policies or operational decisions at the Commission.
Thank you for that input. And does anybody have a motion that we adopt the proposed draft of the Commission designated filers and disclosure categories under the conflict of interest?
So move.
Second.
All in favor?
Aye.
Aye.
Opposed? Passed unanimously.
Thank you.
Executive Director's report.
Yes, the first thing I would like to recognize is our new Deputy Director, Jessica Bloom. As you can see, she has hit the ground running. She has a lot of great experience in a variety of areas, including public records and information. And so one of the things that we will be doing and have actually started looking at is our own records retention schedule. There are, as I think the Friends of Ethics letter to you all this afternoon pointed out, they're very accurate. A number of our policies, including our records retention policies, are outdated. And so we want to make sure that we're also following leading practices. So that is one of the things that Jessica is going to have on her radar, in addition to looking at our enforcement regs and really trying to sort through the most constructive way to make sure that we're doing rigorous and strong and clear enforcement and that people know what to expect when they're in that process. So I just wanted to welcome her officially. I did introduce her at our last commission meeting, but she's been here for over a month now and, as I said, has hit the ground running and has been a terrific asset already. So I'm sure you welcome and join me in welcoming her. The other thing I would say is I look forward to introducing to you our mayoral senior fellow at the October meeting. Gayatri Taikandal is going to join us. Her bio and some information about her is in my report. She will be working as a placement in our office for the next year, and her primary focus is to help us make our website accessible and provide new tools and information for people to really engage with the information we put out there so that it'll help promote compliance and understanding of our laws. We also have positions in recruitment. There's a lot of information that we need to provide the Department of Human Resources to make sure that we can post our positions that we have in our budget. I think we're on track for doing that. We have one more to initiate, but I'm hoping that in the next week we'll be able to post two positions, the Senior Policy Analyst position and one of our Education and Compliance Assistant positions. And then the next will be starting with the enforcement positions that we have, which, as you know, we desperately need. I have attached to the report as well our new information about our new organizational structure. There's been a lot of activity underway over the last couple of months since the Commission met. Chair Rennie attended a meeting of the California Fair Practices Commission Chair and California Forward, who were having a public discussion about the Political Reform Act and ways to restructure that document to help people to have it be more accessible. As you know, Proposition T is the measure now, as it was named during the random process through the Elections Department. The Commission's ballot measure that will proposes to further restrict lobbyist campaign contributions, bundling, and gifts. As I understand today, the Elections Department now has the entire voter pamphlet online, so that information is out and in circulation, including a proponent's argument that the Commission submitted on behalf of Commissioner Rennie submitted on behalf of the Commission. We've been making some progress on our audit reports and continuing to also provide you with information about our enforcement statistics and where we stand. I'm very hopeful that now with Jessica here and her experience and with the ability to hire new staff, we're all looking forward to seeing some progress on bringing forward and resolving appropriately cases that have been stale. We don't disagree with anybody who is concerned that it's taking too long now to appropriately investigate and get to an appropriate solution for our enforcement cases. So we look forward to sharing that information with you as we go forward. And then lastly, I would just say that we have also the annual policy plan, which I inadvertently did not attach to my report that was distributed. So I have copies on the public table and provided for the commissioners as well. Again, just a monthly snapshot to help everybody keep a sense of where issues are that have been identified to be on the Commission's policy discussion for the coming year. Clearly, as our meetings move forward, new issues will be identified, and we'll work to place those in an appropriate place, given your direction about where you'd like to see it. So, with that, I think I've highlighted. Everything that I need to for now. I'm happy to answer any questions.
Any commissioner have any questions?
Director Pelham, with regard to the unfilled positions, since they won't be filled until hopefully before the end of the year, what impact will that have from a budgeting standpoint, since we'll have unused payroll between now and the end of the fiscal year? Will that is it a use it or lose it scenario?
Yes, it is. It's always a use it or lose it. The budget process, you may recall, only provides funding for essentially 0.77 of a full year body. They assume in the budget process that it will take probably about 3 months or more to hire the position.
So will then in the following fiscal year, though, we'll have a full year run rate then?
Yes. Yeah, we would still have the full positions authorized in the coming year. But it is important to get the positions in as soon as possible, clearly, for the work that we have to do. When we don't have the positions in, we do accrue salary savings. We can use those for some limited other functions on an as-needed basis. But it's obviously the priority is to get those positions filled as quickly as we can.
Thank you.
Any public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. Let's talk about what is always missing and is missing in this report. Anything to do with the Sunshine Ordinance. Despite the fact that we've heard a few times this evening about this Commission's responsibilities under law, enforcement of the Sunshine Ordinance is never mentioned. After all, what could you say? We have never and will never do anything to enforce open government laws. We don't give a damn what the citizens of San Francisco passed by this 2/3 majority. We won't enforce it. Not only that, we will do everything within our power to prevent any citizen attempting to provide any level of transparency from achieving their goal. Adding insult to injury, we will openly demean and disparage such efforts. As far as open government goes, you could paraphrase Walt Kelly in Pogo. We have met the enemy, and they is us. What a joke on us. And by us, I mean the citizens of San Francisco. You can sit up there and say, I'm tedious. But what is the real expectation? That if you're fighting for something you believe in, that you will say it once and then go away and not bother them anymore? That seems to be the case. What you resist persists. And if you won't respond, then you provoke a reaction. It's basic psychology. You watch people. Just as when Mr. Keene was talking, I got up and walked out of the room. I wanted to show the same level of disrespect that Commissioner Kopp is showing now by keeping his head down and not paying any attention. That's something that boards and commissions do. They disparage the public. And instead of doing what I believe the law requires, which is to encourage public participation and attendance at public meetings, they do things which discourage it. Look at this room. Who pays any attention? Who comes to these meetings? Who thinks it's even worth the effort? A few of us. Some who want to get on your good side, so hopefully you'll do something right. They're still working under the old premise of, oh, well, if you're nice and polite and kowtow, maybe they'll work with you. But I've learned my lesson. You don't get anywhere being nice. And besides, this is not a forum for being nice. This is the political arena. You are politicians, as much as the commissioner earlier would say, "Oh, I'm not a commissioner. I'm not a politician." Yes, you are. This is a political theater, beginning to end. It's all politics. And every one of you knows it. It's just you don't want to admit it.
David Pilpel. Just wanted to highlight a few things. Actually, the agenda refers to the ED's report with the date of September 21, and the final report was dated September 22nd. So we should just proof the final agenda before it goes out. Appreciate the detail in the executive director's report. If this is what we can expect every month, I think we're doing fine with Leanne, and really the level of detail is appreciated. There wasn't a meeting in August, so maybe it's twice as much as we would normally see, but I do appreciate it. In particular, the attachment 6 with the age of the open formal complaints and the matters in preliminary review. I've asked for this for many years. It's great to see it, and hopefully we'll make this a regular part of the report and not just a quarterly thing, if there's a way to make this monthly. Excellent, excellent. And the policy program is appreciated as well. The final thing I wanted to highlight on page 6 of the report, the BDR accounts, the Bureau of Delinquent Revenues. There's one in particular that concerns me. I know we're going to hear about the Mark Farrell case in a couple of minutes, but the Chris Jackson matter, I've talked to Jessica about this a few times in the last couple of weeks. And by the way, I find Jessica to be very helpful and refreshing new addition to the staff. But with regard to Chris Jackson, he served on the community college board for some time. He ran unsuccessfully for supervisor, resigned his position, left town. I understand he's now living in Oakland and is a candidate this November for the Oakland School Board. I'm informed that were he running for a San Francisco elected office, because he has this outstanding balance, he would not be able to be certified as a candidate were he elected in San Francisco. However, that's not the case since he's running in Oakland. I don't want to say too much tonight. I think you should calendar this matter for a future meeting, because I understand that he has not made the payments that he agreed to under his stipulation. I just think people get into a bad place from time to time, whether it's about forms, fees, fines, whatnot, and they have an opportunity to correct that and get out of that bad place and get into a better place.
Wait a moment. I'm going to interrupt you,
Sorry?
Mr. Pilpel.
Sure.
Do we have a judgment against Mr. Jackson?
We have one.
Huh?
We have one judgment. So.
We have a judgment.
Yeah. Yeah. It's a little complicated, but Mr. For the past executive director approved a series of payments to be made for the total payment plan.
Take it from the top. Do we have a Superior Court judgment?
We have one, but it's not for the full amount that's owed. So Mr. Jackson.
Why is it old? A judgment's in effect for 10 years.
No, not owed. We have a judgment for a small portion of the total amount owed. But because we only referred the amount owed at the time of the first missed payment to the Bureau of Delinquent Revenue, they only collected or obtained a judgment in small claims court for that small amount.
So why don't we go back
We did.
and get a judgment for the balance?
Absolutely. We referred the matter to BDR and asked them to go to.
When was it referred?
Last week sometime.
Recently.
All right.
Yeah. We learned that he had missed additional payments, so we actually accelerated the total amount owed and referred the entire $6,100 that remains to BDR, and now we're done taking payments.
Thank you.
Anyway, there's a little more to it. Again, I didn't want to get into all of it tonight. I think that you should calendar this matter for further discussion. If he missed payments under the stipulation, the Commission reserves the authority to void that entire settlement and bring the entire enforcement matter back. So that is an option.
How much is involved in the first one and the balance?
The current balance that I understand is $6,601. There may be additional.
What was the amount of the judgment?
The judgment was about $2,500, which reflected some amount of principal and some additional city costs for the treasurer's office.
I don't know. Why does it have to come back? I'm asking this rhetorically to us. Why didn't?
I think what is because it may have been a settlement.
It
In
was.
other words, where we entered into agreement. He owed more, but we entered into agreement. But the provisions say that if you don't make it, the whole thing comes back. In other words, that's I assume that's what's in that document.
Right. It was a stipulation that was agreed to by the commission.
Right.
In any event, again, I just think that if someone wants to run for office, that's fine, but they should have their forms and fees and fines up to date before they do so. And I'm concerned that there's a current candidate who's in this bad place. So if you would see fit to either collect the entire amount or, if that doesn't happen, to bring the matter back before the commission for further discussion and, considering all of your options.
I think that probably fits under item 10.
Then I'm ahead of
the
things.
next one we're going to.
Then I don't have to speak then. Thank you.
All right.
All right. Thanks very much.
Item 10 is discussion and possible action on items for future meeting. Now, Commissioner Kopp, during the course of the discussions tonight, you've mentioned 2 or 3 things that you would like to have discussed with the commission, and as was pointed out to you by Mr. White, because they were not agenda items, we've got to put them on the agenda, I assume, if you can recall what they were.
Yeah, well, in terms of the overreaching issue, it's what I observed from reading the list of pending investigations. And again, this is a new administration. But the delays are remarkable. And I would like that put on the agenda and go through those. I don't want to take 10 minutes on every one, but and the second part of that is, and I will announce this publicly, many of them bear a notation that the district attorney is investigating, and therefore, hands off, we're not touching it. And I know that's a principle in criminal law investigations, which Commissioner Keene knows better than I, but I'm approaching this as the new boy on the block. And I don't believe there's any law which prohibits us from proceeding. And I think as a matter of policy, it should be on a case-by-case basis. And I'd like to raise that.
I agree with that, and I've raised that, I think, in the past, and particularly in regard to the former executive director, using the opportunity to defer and sort of get off his desk matters by saying, well, this is going over to the district attorney or someone else is looking at it. And we used to get those things summarily from him. So I think it bears more inquiry. There's no reason in many instances, I think, for us to not proceed parallel to the proceeding of another body. That was part of our not doing that was part of the reason that got into the whole brouhaha about the statute of limitations in the Farrell matter. So I think we should indeed visit that.
We'll put those 2 items on the agenda.
Yeah, and just to make sure I'm clear on what you're looking for, just as I would refer you, for example, on the annual policy plan, for a more global discussion on policy, we have tentatively planned for the November-December timeframe. We've been at the staff level with Jessica starting to dig into the enforcement regulations, but that's a sort of a broader policy about how we work with other enforcement agencies and what our procedures are. It sounds like that may be one piece of what you're looking for, but then I'm also hearing Commissioner Copu and Commissioner Keene looking for a specific discussion of pending complaints that are open investigations right now. You're looking to review that. And if so, that matter then would be scheduled for a closed session discussion at a future commission meeting. Is that correct that you're looking for both of those items?
Yes.
Okay.
But the latter item, as to the specific complaints and when they came in and where they are, is a matter that would have to be in closed session.
Correct.
Any public comment on items that you would like to have on the calendar?
Sorry, not to interrupt public comment, Chair, but one other thing that Commissioner Kopp had mentioned while we were discussing the Sunshine Ordinance issues is a possible review and proposed recommendations for changes to the Sunshine Ordinance. Are there any specific questions that you wanted us to review, and is that still something that you would like us to do? And what's your time frame?
Can you do it by the next meeting? No. How about the meeting after? Huh? Okay, how about the meeting after that, November?
Well, what is the process that we would want? Yeah, what would be the scope? Would you like us to have interested person meetings prior to presenting you with the changes or proposed recommendations, or would you want those to happen after?
Yeah, that would satisfy me.
Then maybe December. Yeah, December.
Good evening, Elena Schmidt with Friends of Ethics, and let me add my welcome to Commissioner Kopp. It is going to be interesting to watch this. I am going to repeat pretty much what you just heard from our new Deputy Director, which is I want to make sure that as you had the discussion about CAWA and you put item 5 to bed, the issue is still out there, which is you have a number of varying organizations, agencies, saying what should be covered by the records retention, when is it public, when it is not public. But as Commissioner Keene pointed out, transparency is really what you're after. You really want to make sure, or at least from my point of view, you want to make sure that the citizens have a right to the information that they need to see of how the city government is working for them. And so I want to make sure that that discussion is on the table for future agenda items. I think having an interesting persons meeting is very important, and I would hope that Director Pelham and others would sit down with the other organizations, Sunshine's Task Force, the Records Retention, who's ever in charge of all that, to work through how can we make sure that there's not conflict, but that in fact we're getting a clear signal to the citizens of what's important. Thank you.
Thank you.
Thank you.
Any other comment?
Charlie Marsteller again. Yes, on following up on Elena's questions or comments, I think I think what you're looking for is a rewrite of the ordinance or an amendment, which is by supermajority. So you want to build your coalition, you want to get all the interested stakeholders together on the IP meetings, and there shouldn't be that much of a rush because we do want to make sure that everybody has input to that process. And I think we will all find it to be very helpful. On a follow-up point I mentioned before, I see some things in the public financing of campaigns system where the concurrent and proactive auditing that's supposed to occur during even the course of the campaign as reports are filed, that perhaps the documentation that is lost oftentimes could be submitted with the report we could make a special class if you're accepting public financing, that you basically have a mini audit per every month, where they really do a facial audit to make sure that the receipts are submitted with the report to document everything that's stated in the report. That way it keeps the treasurer on top on their toes. And you don't have this scramble after the election to try to document everything that happened in that chaos of a campaign. It's better to do it concurrent with that campaign process. So that would be my other thing, and that's an issue that came up as well with the lessons to be learned from Ms. Sweet, which I wish her luck in. But I really wish she would terminate her committee. And if I see her, I'll tell her.
Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I wasn't going to comment on this particular item, but I heard something during the discussion that I just couldn't let go. All this Durham and Strong about the length of time investigations take, and as Commissioners Keene and Rennie will remember, I filed a complaint with this commission in March, and I had an investigation and a denial of hearing within 30 days. I filed a second one in April, and I had a hearing, I had an investigation and a denial of hearing in 48 hours. So I don't know what everybody's complaining about, saying investigations are taking too long. 48 hours, that's a really good turnaround. And if you can't tell, I'm being sarcastic. Because there was no investigation. There was just a blatant effort to look at what I had put in and find reasons to ignore it. The same thing that happened when I brought a complaint to the task force that was referred over here the last time, and you held a hearing while I was out of the state. You don't like what I have to say. And you know that if I had been there that night and been able to actually pursue the complaint that I had filed, I would have put a lie to Luis Herrera, who said, oh, no, we can't let Mr. Hartz project a PowerPoint slide in Corrette Auditorium. We would have to spend $41,000 to do that. Commissioner Sullivan at the time got it. He said, didn't you look at any other way of allowing the public to do this? Oh, yes, Mr. Herrera responded. We looked all, but the only thing we could do was all this construction work in Corrette Auditorium. We had to spend $40,000, and we didn't think that was a good use of the time. The only thing that actually achieved is the other group that was involved in the case, the Friends of the Library, no longer come to Library Commission meetings. Because the question was asked by the task force, well, you say that you let the Friends use the overhead because they're invited. Would you ever invite Mr. Hartz? And of course the answer was no. Because then we'd have to let him put up a picture or a graph. And if we let Mr. Hartz put up a picture or a graph, we're really going to look bad. It's bad enough what he says. If he has visual aids, oh, what a nightmare. But the Friends, a group that raises $6 million a year in the name of the public library and spends it without any oversight from anybody in the city, a group where the city librarian secretary has said, we have no fiduciary responsibility related to this group. They get free access.
Thank you. All right, hearing no other public comment, I hear a motion to adjourn.
So moved.
Second.
On adjournment?
No.
I thought that all the public comment we've had satisfies 13, but if you say item 13 requires me to say, do we have any separate comment?
Even though
We have dismissed, we have continued it.
We did that right at the beginning, and we took that up right at the beginning, and we continued it.
3 hours, 4 hours.
Yeah.
Yes, for every agenda item that appears on the agenda, the commission is required to take public comment.
All right. Any public comment on the item 11, which has been continued to October, some date in October at our next scheduled meeting? And I would hope that if your comments relate to the substance of number 11, you would wait until October to give us that comment, because we'll never remember what you said.
I just wanted to say tonight everybody's listening to the president's debate, the presidential debate. And that's normally, I wanted to inform our new arrival, Mr. Kopp, that we have a large turnout generally. So a lot of young people, millennials, they're activated through an organization called RU, Represent Us. And then, of course, Friends of Ethics, and then a lot of other interested parties that attend these meetings. So tonight, they're all out watching the debate. God bless them.
I was looking at the ratings, and it appears that we outdid them in terms of
I'm not
viewers
surprised.
out there.
You had the hottest agenda in town.
No question.
We won our time slot.
And so much so you had to postpone some items because nobody was here. They were all tied up. No, I appreciate the fact that some items have been deferred because there will be public interest in those items.
All right, thank you. Any other public comment?
David Pilpel, I still think we made the better choice by being here tonight, but I could be wrong. I wasn't here at the beginning of the meeting. Did I understand that item 11 is being continued?
It's been continued, yes.
Was there some introduction or explanation about the status of the case? Because I know it's been continued several times for a hearing on the motion to strike.
There wasn't any discussion about it. It was continued in part because one of the commissioners had emergency leave.
Okay, and you wanted
emergency, we want to.
And you wanted all 5 commissioners. Okay, but as I understand from the agenda, although the attachments don't really speak to it, the proposal is a $25,000 settlement from Supervisor Farrell to the city and mutual release of claims, and that would end the matter. That was the proposal in sum and substance.
Correct.
Okay, and we'll talk about that next month. And so nothing's going to happen until then. Okay. I think I'm good. Thank you all very much. Great meeting tonight. Thank you.
I hear a motion to adjourn.
Agenda item 12.
Item 12 is for more public comment. You have some, I'll call item time, additional opportunity for public comment on matters appearing or not appearing on the agenda.
Commissioners Ray Hart, Inspector, San Francisco Open Government. I've had people walk up to me in the street and say, you know, I saw you on SFG TV. Good job. Give them hell. I've never had one person say, gee, you're rough. I've had people tell me maybe if you aren't so in their face, you'll get a friendly response. Years of experience have taught me one lesson. No matter how friendly, how polite, or whatever you are, the most you can hope for is to provoke a reaction. George Orwell said, in a time of deceit, telling the truth is a revolutionary act. As regards this body, maybe Andrew Carnegie had it right. He said, as I get older, I pay less attention to what men say. I just watch what they do. Over the years, I've repeatedly asked members of this body to tell me anything they've done to make city government more open, transparent, or honest. The answer is always silence. Truly deafening silence. The citizens of San Francisco know their government to be corrupt. And I believe they should be aware that you are not part of the solution, you are part of the problem. There are at least 2 of you who can take some satisfaction in the fact you weren't here during the 5 years when there was no increase at all in the budget. Although I was kind of dismayed to hear you gloating over the fact that the mayor approved a huge increase the last time the budget went around. Well, what choice did he have? He had his aides being indicted for accepting illegal bribes. What's he going to do? Say no? Especially when everybody pointed out that it went on for 4 or 5 years where the budget didn't go up a single dollar. B.F. Skinner, the father of behavioral conditioning, said that any behavior that's rewarded will be repeated. And believe me, your reactions tonight to my public comments have been very rewarding. So I will look forward to seeing you next month and every month after that.
I now hear a motion to adjourn.
So moved. Second.
All in favor?
Aye.
Aye.